number 20 in the supplementary list. I'm only requesting if the same could be taken up with item number 2 because there's similar matter also. I've mentioned and got it listed. Great.
Lordship, may I pray for the listing of IA for tomorrow, Your Lordship?
Tomorrow.
The main matter, Your Lordship, is already listed tomorrow. It is that bank guarantee matter.
Huh.
We have filed an IA for extension of the bank guarantees or for furnishing some other valuable security because the guarantees are otherwise due to expire.
So their court can extend.
No, for a direction to them to at least make sure that they, or in the alternative, furnish some other valuable security so the matter does not become infructuous.
May I please, Your Lordship? 2 petitions, my lord, may come up for withdrawal, my lord. On the next 2, on Tuesday.
Lordship, I'm praying for unlisted matter for tomorrow, Lordship. The matter relating to eviction, Lordship.
Eviction.
Eviction of a land of plot of the petitioners. Lordship.
Notice under what section?
It's a government land, Lordship. Notice was served upon the petitioner
Okay.
of the Lordship.
May it please, Your Lordships. Lordships, I beg to mention item number 6 notes. Because in this matter, the parties have entered into an out-of-court settlement, so I have instructions to withdraw the matter, lords.
Okay. Mr. S. Vishwakarma, learned counsel appearing for the petitioner, has submitted that the parties have arrived at a settlement out of court, and as such, he has instruction. He has received instruction from the petition not to press the petition. Mr. Tekka,
I am for 1 and 5. I am for 2, my lord.
Mr. S.S. Roy, learned counsel for the learned central government council. For the respond number
1 and 5.
1 and 5. Mr. N. Dekka, learned counsel for the respond number 2.
2.
Anybody for 3? And who is for 4?
4. I am.
Mr. R.J. Das.
Lord, may I also pray for liberty to come again if by any chance the settlement does not come to fruition?
He has further prayed, he has further prayed for liberty to approach again. R.J. Das, learned counsel for the respond number 4 are present. Yes, Mr. Dekka, any out of court settlement to it?
My lord, he has since he's withdrawing because I don't have any instruction. My learned friend has said the instructions. That part they are saying that my client has said that they will withdraw the matter. That out of court settlement, that part is not very clear. But since they are withdrawing, my lord, we have nothing to say.
No, regarding out of court settlement.
My lord, I don't have any instructions.
Okay, you are withdrawing.
Yes.
Are present. In view of the above submission made by Mr. Vishwakarma, learned counsel for the petitioner, the petition is dismissed as not pressed with the liberty as per report.
The interim order may be vacated.
The interim order stands recalled.
May it please your lordship, my lord. My lord, I beg to mention item number 17, my lord. My senior has some, my lord, personal difficulty today.
Mr.
H.P. Gwala, my lord.
On the prayer of Mr. H.P. Gwala, learned counsel for the petitioner, the case is adjourned for the day. Case is passed over for the day. It is submitted that consent has been taken from the learned counsel for the other sides to make the prayer.
I am for respondent 7 and 8.
Mr.
DJ Methi.
DJ Methi, learned counsel for the respondent
7 and 8.
number 7 and 8 is present. And Mr. Taluja is available.
My lord.
Okay, absolutely. Bro. It is submitted that consent has been taken from the other sides.
Problem.
May I please your lordship? Lordship, I beg to mention item number 13 to adjourn the matter for today. Lordship, my senior is presently
Item
out of-
number
13,
13.
13.
2014 matter.
Yes, lordship, but my senior is out of station.
Why he is out of station?
Lordship, opposite party has given the consent.
Merely concern will not do. Otherwise, next time he will do.
Lordship, kindly,
On the earlier date also.
lordship,
It
kindly.
was
take the
adjourned.
Matter next week.
MS
C. Sharma.
C. Sharma. Council appearing on behalf of Mr. S. Sohan, learned counsel for the petition has submitted that Mr. Sohan is out of station and person.
Sorry, lordship, sir, lordship, I'm from the respondent side.
Respondent side.
Yes, lordship. Lordship, my senior P. Mohanta.
Appearing for Mr. P. Mohanto, learned counsel for the respondent. Which respondent?
All the respondents.
For the respondents. Has sought for an adjournment. It is submitted that consent has been taken from the learned counsel for the petition to make the prayer. Full stop. As the petition is of the year 2014, comma. Please the case. The prayer is allowed as the petition is of the year 2014. Comma, list the case on 25.
Much obliged, lordship.
Yeah, please, Lordship. Lordship, bring for listing of WPC on Monday, Lordship, for admission.
Monday, what is the matter?
Lordship, matter pertains to demarcation of land. Actually, recently on last two occasions, matter has remained left.
Demarcation of land. Which year?
23 matter, Lordship. Actually, pursuant to
Make
order
a
of
prayer
this-
before the rest.
May I please, your lordship. Lordship, I beg to mention item number 14 and 15, lordship. Lordship, can it be adjourned for today, lordship? As
Today?
he's not well, lordship. With the, I've taken consent from the other side.
Who is not well?
Mr. Ekalde is not well.
Mr. N. Kolita,
Yes, lordship.
learned counsel for the learned counsel representing Mr. A. Kolita, learned standing counsel, Industry and Commerce Department, has paid for listing of the case after a week on the ground that Mr. Kolita is indisposed. It is submitted that consent has been taken from the learned counsel for the petitioner and other respondents to make the prayer. As it is submitted, huh? The prayer is allowed. This is also 2014. Leave the cases on 8-2.
I seek my lord's kind indulgence to mention a matter for listing tomorrow. The three bidders who are
Right.
before your lordship, their livelihood is at stake. The tender condition has imposed a stringent condition that in the one bidder has to opt for all the trains in the cluster, which is denying them a level playing field.
When is the last date?
This is a fresh matter, lordship.
When is the last date of submission of bid?
My lord, it is likely that they will open the bid on. the
Last date is already over.
Lordship, tender has been floated, so now it is likely
When is
that
the last date of submission of bid?
lordship, that is over.
Our hands are full tomorrow. Already. Monday.
If possible, lordship.
Monday. That is why I have asked you,
Yes, lordship.
when is the last date of submission of bid?
That's over, lord.
No idea.
Lordship,
Over.
Yes, lord.
Already over.
So
Then
when-
if the condition is stringent, you ought to have filed it at the time of
I had
floating of
filed
the
it-
bid.
Yes, my lord, I had filed it before the vacation. Before the Bihu vacation.
Monday.
Tomorrow, is it possible, lord?
Not possible. Our hands are full.
Lordship, my friend just mentioned item number 14, 15, and it was fixed on 882. My lord, 82 we have matter, my lord. Can it be on 15th?
Okay, 15.
Oblige, my lord.
Promotion item number 1.
After some time, Mr. Talakdar is lax on court number 5 manner, the part had better.
Item number 2 with 20.
Lordship, petitioners are flat owners in a multi-storied building in Beltola. We are 9
Who is the
petitioners.
GMD council? Yes.
Lordship, we are 9 petitioners, owners of 6 flats in a multi-storied building in Beltola. We bought between 2017 to 2023. We are bona fide purchasers. We have annexed all our sale deeds. This multi-storied building was developed pursuant to a development agreement. Lordship, may kindly quickly go through the development agreement, page 105, just to give you an idea of where we are.
No, there are 3 blocks.
Correct. Yeah,
On the
that's
previous, there are 3
what I
blocks,
wanted
3
to show you.
block
Yes, Your
building.
Lordship. So there are
2 lands. Then why should we go into those aspects? Come to the impugn order, page 133.
Lordship, just before the impugn order, just to know how it began. A writ petition was filed alleging contravention. In that writ petition, there was an inquiry report. Lordship, may I place the inquiry report first? Because we need to understand what is the violation. Lordship, page 129. The violations have changed with course of time. Lordship is aware there's block A, block B, block C. We are residents of block A and block B. C is not of our concern. Page 129. Lordship, that's an inquiry report. Lordship has the inquiry report. In terms of affidavit of the annex, the pages before that. Lordship, the findings. May I read the findings? NOC was given on 6/11/2007. Block C approved plinth area, built up area, etc. But the existing G2 residential building is not demolished, and block C is constructed with a plinth area of 297 square meters with a total built up area of 166 and used as a hotel at present. That's number 2 finding. Lordship, number 4, the next page. So block C finding is that you have used it as a hotel when it was given for residential purposes. 4, Lordship, this is important for us. Proposal for occupancy certificate is submitted by the concerned party, which is under scrutiny. 5 is where the violations are. The change of use of block C from apartment building to hotel is a non-compoundable violation, as hotel is not a permissible residential zone as per provisions of land use admissibility of master plan of Guwahati or GMA 2025. That's the first violation. You've used it for it's a wrong use. You've used it for commercial, block C, which should have been for residential. We are not concerned with that. Addition of 7th floor block A, Assam type of 175 square meter is compoundable from FAR point of view, but it is to be examined from point of setback structural.
Where is GMDA? How it is compoundable? Addition of 1 floor?
1 floor. Yeah. Lordship, the next letter.
Which from? Where from? Where
Lordship,
from GMDA?
Lordship, may kindly take a look.
We'll see.
Okay.
Where from he is saying? Who is this man? Addition of 1 more floor is a compoundable offense. Law is different. Law is different.
No, Your Lordship, law is if there is a violation of a permission, it is always compoundable. Lordship, more often than not. Because Lordship, no, what is not ever compoundable if it's against the law. So if in a green area, you go and build a hotel.
No, I am asking GMDA council, where is Mr. Bora? That day, we asked for Mr. Bora.
I will call him.
Call him. Yes.
So Lordship, there are two violations. One is user, one is 1 extra floor.
I have some
Floor
doubt.
is on block A where we reside.
So this I have some doubt regarding compoundability of this
Now, Lordship, the next,
addition of.
Lordship, next page. How do they deal with this too? After 2 years, this your Lordship is aware it's in November 20. This is November 20, page 129. After 2 years, at page 131, they write to the builder. Page 131. This is the second violation, your Lordship. And you see the reference, your Lordship? Your proposal for occupancy certificate, 3620. With reference to above, your proposal for occupancy certificate is approved. This is after 2 years of the inquiry report. For block A and B, in this regard, you are requested to deposit an amount of 22 lakhs only as penalty for excess area constructed and renewal fees. You are requested to fulfill within 10 days. So they have made this compoundable. This is regarding what is a violation on our building. Regarding the violation of user, your Lordship may kindly turn to page 132. That's the next page, your Lordship. This is 1011. In person, Lordship, there's a writ petition filed against, this is how it's come up. There was originally a writ petition filed 4389 by one of the flat owners saying violation, pursuant to which there was an inquiry report. And now this is regarding the change of user of land. They say, in pursuance to order of the Guwahati High Court, etc., powers conferred on hereby order sealing of the premises of G+4 in block C because of violation of change of use. This has been changed, your Lordship. Now it's become 139. The High Court has desealed it. So this violation is cured itself. Lordship, page 139 at page 141. So one violation, they have said compounded pay. The other violation, the High Court on an undertaking by the owners and the flat owner have desealed it.
Okay, where are the building bylaws, Mr.? Where can I found?
Lordship, my colleague was going through this file, but whatever I remember, Lordship, in this particular plot, Lordship, NOC was granted for construction of.
1 minute, we are not going into that. You can hear.
No, what I'm saying, Lordship, this matter cannot be looked separately from the other matter, Lordship.
Both are taken up together.
Lordship,
Where are the building bylaws?
Lordship, GMDA Act.
2006.
Guwahati Building Construction Bylaws.
2006. GMDA Act.
Where we can found that compoundable, non-compoundable thing? I'll pose a query. That is why I am looking into it.
2006.
Change of use is one part.
Lordship.
No,
Lordship, in this case, Lordship, there is specific violation of NOC, Lordship.
Right, two things. From the inquiry report, in the inquiry report, you have said that addition of 7th floor in block A is compoundable. Because in another case, I have found that as per your bylaws, addition of floor is not compoundable at all.
Yes.
And that bylaw have been affirmed by the Supreme Court and ordered demolition. How can you find record that addition of another floor is a compoundable thing? That is what I am trying to find out. Oh, yes.
About 9 seconds.
Okay. Page 130. There are two violations found. One is change of use of block C.
Yes, sir.
From apartment building to hotel. And second one is addition of second floor Assam type area, which is found compoundable. Okay. But it is to be examined from the point of setback, structural liability, and NOC from other appointment. Yes, carry on.
No, it is compoundable, but so far as this particular building is concerned, that is not yet decided, Lordship. Lordship will see the next slide.
Okay.
But it is to be examined from the points
Okay.
of setback, structural stability, and NOC from the other apartment.
Yes.
That is incorrect, Your Lordship, because the next page refutes this contention. It's after 2 years and they have compounded it. Page 130, which he just read, he's correct, but it's to be examined from the point of setback, structural stability, NOC from other apartment owners. Next page, this is, Your Lordship, I showed you, page 129, this is of November 20. The next page is of April 22, where they consider it and says your occupancy certificate is approved. Approved, and your request is to deposit. Now, Lordship, the problem is not this. This is 2, and Lordship, I was just showing you the High Court order which orders de-seal on an undertaking that you will now use it for residential purposes until you get permission from the authorities to use it for commercial. So the non-user has also been cured. So it's only about 7th floor. Lordship, at the maximum, Your Lordship, it is my humble
There is a
submission.
so-called notice.
Yes, Your
Come to
Lordship. Now,
133.
those are the issues. Your Lordship, may kindly first see page 133, how it begins.
Yes.
Page 133.
Let us read this.
Yes, Your Lordship. There are 3 of them. We will go chronologically, Your Lordship. So up to now, it was 7th floor and wrong use. Now they come up with something else. This is 19th of November 2022. May I read, Your Lordship? In continuation of the earlier notice, 12/10/22, I'm here to state that you have undertaking unauthorized construction and material alteration in existing building block A and subdivision of the plot in manner and at the place specified in the schedule below with violation from the approved drawing and NOC dated 6/11/2007. And then, Your Lordship, they talk about this. Most important, Your Lordship, is 3rd paragraph. The letter issued. The letter issued to Kasliwal, who's the respondent number 9 here, the builder. Viday 6/4/22, which I showed you, Your Lordship, asking us to compound, and OC is approved. That's the letter. 6/4/22 is hereby cancelled. This is what impugns us, Your Lordship, the flat owners. Then, Your Lordship, manner of development and construction. So they have crystallized what the violation even in this letter is. Construction of the 7th floor, roof in block A, where we reside. Unauthorized subdivision of plot by constructing a brick wall between block C and block AB. So this is a new one.
Now let us come to 137.
Yes, Your Lordship. Lordship, perfect. Yeah, that's Your Lordship. That's the next letter. So they've added one more construction of wall as a violation. Now we come to 14/12/22. That's the next month. Whereas NOC for 3 apartments was issued to Otis, 6 based on power of attorney executed and landowners. Whereas it has come to light based on a reply filed by Otis that the landowners, Rabha, are authorized to construct block C by executing an MOU with the landlord on 3/7/15 in violation of the power of attorney and other agreements executed earlier and NOC dated 6/11/2007. Which was issued over the entire plot. It is also stated by the builder that since block C is constructed by the landowners, the builder shall not be responsible for any discrepancies for the work block C. Whereas landowners constructed block C in violation of approved plan, constructed and used block C as a G+4 hotel without dismantling G2 building in place of an apartment building permitted originally. Now, this is important, Your Lordship. This is the violation which they pin on. Since the NOC is not transferable, the construction carried out by the owner and the existing G+2 building is therefore treated as unauthorized. Further to this, the original plot as approved is subdivided into 2 distinct plots by constructing a brick wall, one having block A and B on one side with independent access from secondary road, and the other plot owned by the landowners having existing G2 building and a newly blocked C. So, Lordship, here the violation is that the builder was supposed to construct, builder did not construct, the owner constructed, and therefore the NOC is transferred and NOC is not Where they get this from is difficult to understand. Next page,
Easy to
138.
understand.
Next page, 138. This authority is of the considered view that the original plot and permission is bifurcated into two parts. One part for development by builder, that is block A and B, and the other part is developed by owners. The earlier proposal for occupancy certificate submitted by Otis found to be misleading as the proposal is submitted over plot of land, entire plot. Although block C now is constructed by the landowner based on MOU, as mentioned earlier in violation of POA and other agreements, and subsequently, the plot is subdivided into two parts with independent access. Now, what hurts us as flat purchasers of flats which are built according to sanction plan is, therefore, as communicated, 6/4/22 occupancy certificate proposal stands cancelled. This is what is our problem. And then they say, you revise, you give us a fresh proposal
Right.
with revised.
Suppose because perhaps there were originally proposed block building A, building B, building C over two plots of land. And development agreements perhaps was entered into and with the condition that the C will also be sold. Flats in C might be, or there could be a provision there, proportionate share of the land.
Lordship,
No.
Flat owners will be
One-
having.
One plot of land, NOC was granted for construction of 3 building A, B, C. A and B has already been constructed. The plot where C was to be constructed, in the meantime, handed over to the owner by executing different, another.
Definitely there are changes.
And lordship now, between the two plots, one wall has been constructed.
Even if it is not wall. Things are that two buildings originally builder was supposed to construct three as per the NOC.
Lordship,
In the meantime, some arrangement, I don't know what is the arrangement. Two buildings completed by builder and one is exclusively by the,
owner.
so it is like a own house,
Lordship,
building C. Please
yeah, yes, Your Lordship.
hold it for for a moment. Then everything has changed. So building A and building B is by the builder pursuant to development agreement. But building C was originally also included. But that was later on, because of the arrangement perhaps, that was excluded. And it was supposed or maybe constructed by the owner. So it is like a own house, independent house. There is nothing with the purchaser, not flat owner, but original NOC was granted. So your thing is not foreclosed because therefore builder is directed to furnish revised occupancy certificate proposal.
Lordship, the problem, sorry, may I?
So why we should go into this,
Lordship,
all these aspects? Because that is why I asked on the last occasion. There is a provision for appeal. Who is the appellate authority?
Lordship, I can't go to RERA. RERA has no jurisdiction over.
This is an order passed by GMD authority. And Mr. Bora was there because there were earlier writ proceedings also many disputed questions of fact which requires field inspection. Then he placed before this court that there is a appellate authority, and appellate authority is the district judge of the jurisdictional district judge. Why should we go into all this in a writ proceedings? That on the previous date, we asked Mr. Bora, I think, Mr. Nayak was there. Section 71.
With your Lordship's permission, the second writ petition is filed by the builder. I just take 10 minutes of your Lordship's time.
We'll find out whether
Once my learned.
whether district judge is the appellate authority or not.
Yes, sir.
Let us see section 71.
2006.9. 2006.
This, all these issues might require some discussion between the parties.
No.
CMD এখন করতে হলো।
85
এইখনত আছে জানো?
এই ৰঙা ফ্লেগ
Yeah, yeah.
এইখন 71
71 and 72.
Lot. Appointment and duty.
Where is the appointment notification? Why should we go into this?
Lordship, because my occupancy certificate is in challenge. And I am a bona fide purchaser.
No,
Lordship-
your occupancy
No, Lordship,
certificate, if
no.
you come to page 134,
Also,
please,
there is a question of law that emerges.
what question of law?
What does GMDA give permission for?
Hmm?
Does GMDA give permission for development, or just GMDA give permission as to who must develop? Lordship, there's a slight bit of confusion. There was a development agreement between the builders and the owners.
Now, this agreement that.
Lordship, may I
Block-
take you to the
Block B-
admission?
I'm asking you, Block C, originally NOC was submitted or granted on
Lordship,
2007,
7, yes.
right?
Lordship,
Then
if I show
some
you those-
subsequent development
Yes,
took
if I-
place. Now, whether this subsequent development were brought to the notice of the GMDA authority, please show me.
Yes, Lordship, question is whether we needed to or not. That is what hinges everything on it. Lordship, may I take you first to the development agreement? It's at page 105.
Your locus will see, your locus will see.
105.
But tell me whether these changes which the owner and the builder entered into after issuance of the NOC was brought to the notice of the GMDA authority or not. Please, builder.
I just come.
You are after the builder. So
Yes, yes, yes.
he might be having better knowledge about all these developments.
I go around your lordships.
You are maybe the victim.
Yes. 2006, there is a development agreement between a builder and an owner. Normal developer agreements which are executed where they say certain amount of buildings will be constructed, you will be given a proportionate share on the construction. Now, what is this agreed is that there will be 3 buildings which will be all constructed by me. Agreed. With a proportionate share of A, B, some to the builder, C, which is also included in the same agreement.
But this proportionate share or
Yes.
percentage to the builder and to the owner was out of the entire construction.
Yes.
Right?
Yes, I agree. The change, I'll come to the change. Once the development agreement was executed, a power of attorney was issued. In terms of the power of attorney given by the owner, I'm still saying is the owner because he validly remains an owner even today. So that's the problem that we face today. Ownership right, according to us, still is with the owner. It remains with the owner. So the power of attorney that was given to us, we go and apply for the NOC. NOC was granted. If you see, your lordship, in my petition, the NOC is given to the builder.
Right. With the NOC, before the NOC, there used to be a power of attorney and there used to be a development agreement.
Correct.
Right?
Right.
This development agreement was for construction of building A, building B, building C, and rights
Right.
and obligations.
Right. Right.
of
I'll come to that agreement.
builder and the owner
Correct.
flowed out of those development agreements.
Absolutely right. Absolutely.
So your share or whatever your right or whatever obligation were defined in that development agreement that I would be having
Correct.
25% or
Correct,
50%.
correct.
Owner will be having
25%, 20%, whatever
whatever,
the shares are.
but
Right.
all these are all for all the buildings.
Correct.
For all the buildings.
Correct.
Right.
Not C. Not C. I'll come to that. That's why I'm saying, your lordship,
Show me, directly show me.
I'll just come to that. Just let me give
Directly
the facts so that your lordships will understand where I am coming. Deed of agreement starts in my.
No,
petition at
I
page 45.
have to be clear on
I
facts.
understand. Page 40.
Show me.
Is my deed of agreement that we've executed. 2006, clause 8, page 49.
Where is the original development agreement?
That's the agreement. 2006. Page, it starts at 45, the relevant part is at 49, what I'm reading. It's clause 8,
40,
49, clause 8.
45.
Yes. The second party, that is the builder, may I read? Para 8. Will provide the first part, landlord. I'm reading clause 8. 25.
Come to page 46 first.
Lordship, please. Yes.
This agreement for the entire land?
Yes. I'll come to the division. That's why I'm reading clause 8. It will become much clearer, your lordships. Page 49. May I just read, your lordship's permission? Clause 8. The second party builder will provide to the first part landlord 25% of the super build-up area of Schedule B and the whole construction over Schedule A, including the proportionate cars parking space on the said building, together with the right, title,
Who is
interest
second
in...
party builder?
Yes, I'm the builder. I'm the builder. I'm going to include the builder shall have no right, title, interest in landlord's allocation and proportionate share of common facilities, provided at least 10 numbers of fully furnished flat on Schedule B should be delivered to the first party on completion of the project, free of cost, provided of the area of the land permits to the builder, area of the land, to the same, the allotment of the area of 25% of the first part shall be in the following manner. So Schedule A is the owner. Block C. So the NOC that was given to me, your lordships, was given to me for your lordships are right. Subsequently, what happened, I started construction from 2008 after the NOC was given to me. Till 2015, the things were going all right. I did construct.
Suppose ultimately,
Yes.
after this NOC, some arrangement had entered into between
Completely
the
principal and agency.
Now builder says, owner says that in this area,
Right,
I will build
right,
my own house,
Right.
residential house,
right.
right? So calculations are to be made according to the
I agree what your
I'm not
lordships
going
are
to
saying to a
block-
certain extent.
calculation. If Mr. Fukon wants to, suppose Mr. Fukon has entered into
Ji.
and develop an agreement initially
Yes,
with the adjacent landowner and the entire plan was submitted on the consolidated block.
yes,
At a subsequent point of time,
yes,
dispute arose.
right,
Then Mr. Fukon says that no, I will not go into that. I will build my own house
right, right,
inside this land area.
right,
Right.
right.
So there is no connection with the
Previous NOC,
previous NOC.
permission given.
Yes.
Yes,
Then your whatever floor, etc., setback, etc., are to be calculated as per the building bylaws,
right,
right?
right,
Within that area,
correct.
within that area, with no connection with the
The previous NOC.
other NOC, right? And all this, it should be residential.
Correct,
The use you have changed, that has been rectified.
correct.
That is a different thing. But otherwise, this building has to be calculated within, as per the land area on which it is constructed. Because suppose 10 feet, 10 feet, 10 feet, 10 feet setback of so-and-so, far of so-and-so, these are to be calculated on the basis of this land area. We are not concerned with this.
Correct.
The owner.
Correct.
Right.
Correct.
As a result, this calculation has to be recalculated.
If
all these things have you brought to the notice of the
I'm just coming to that.
CMDA?
I'm just coming to that, your lordship. 2008 to 2015.
Query is yes or no?
No, I have. I tell you what is
Answer is first yes or no.
Yes, and I tell you why was it intimated. 2008 to 2015, the buildings were constructed. Flats were given. That is how my learned friend comes into the picture. Flats were sold of A and B. C, when it came to the construction, your lordships, I could not do it because of a financial difficulty and I've had a problem. I then requested that the building C, which also falls under the same development agreement, which I was supposed to build, completely supposed to be built by me because that was the permission given to me, could not be adhered to. Therefore, like a principal in an agency, which is obviously an established relationship, they say, you built it. So the owner, when he went to builds, when he goes to builds,
JMD was intimate.
I tell you, lordships, in that circumstances, a writ petition came to be. I tell you why we had to intimate. And the reason whether I needed to be intimated, as my learned friend said, the NOC that was given to me was always given for the entire plot of land to be built and constructed. NOC, would your lordship just give to the NOC once before I come to that? Would your lordship just come to the NOC one? It's at page 50 and 59. Sorry, it's at page 58. The problem is the schedule of the land. I'll come to that. NOC at page 58. This isn't my writ petition. Yes. The permission that is granted is around flow area setback. Just between that, your lordship, there's written one line written in block A and B, grounds +6, block C, ground +4. So this is in terms of the development agreement. A and B, ground +6, C, ground +4. So violation is not on this. The problem that GMDA faced is,
Violation is subsequent development.
I tell your lordships why. Since I could not build, it's a principal agent. So today, if I want to develop my land, I give it to an architect. Architect brings it a builder. Builder says I can't do it. Do I need to go back and change the entire cause of action in order to build a part which is already been given an NOC?
You have made.
No, but then the bifurcation has never happened. Land remains the same. Ownership is still with the owner. If your lordships are asking me if there's a violation of the 7th floor, that the GMD, I think my learned friend is absolutely right. They will have to say there's a violation.
You suppose the purchaser,
Right.
because block A and block B, purchases are in block A and block B.
Right.
Right.
That's a residential part.
Because there many things are going to change.
Right.
One of the thing is proportionate area of land.
Right.
Right. Originally, this is the area.
Right.
Right. But because of the subsequent development, this got bifurcated. No. In principle, that is what has happened.
No, that's all I respectfully, that is why we are here. The bifurcation never happened. If the GMD is
Mr. Fukon,
the
when
bifurcation
you
with all
have
due respect,
changed unilaterally, tell me when this has been changed, this agreement or whatever that you build block C.
not for
Where
the
have
NOC.
you brought to the notice of the GMD? Please tell me.
No, lordships, all I'm trying to tell you, lordship, is the
All
change that
these
your
have
lordships are
come
asking.
to the fore when a writ petition was preferred.
I,
Is it not?
yes, no, but the agreement was executed in 2015.
Whatever.
So if I had
That-
to intimate to the GMDA,
That you
lordship,
cannot change.
no. The
This
change,
NOC, you should have intimated to them.
no, because there was no reason why I respectfully submit is this, because the NOC still continues. The ownership still remains with him. It's only a building that I'm supposed to construct. It's only a change in hand in construction. That's all.
Come to the agreement.
Yes. First, may I read the schedule, your lordship? It will
No,
become
no,
clearer
no,
to your
no,
lordships also.
No, development.
Yes, I'm reading the development agreement.
No,
That's
no,
at page
not the
45.
development agreement. The bill, flat buyers agreement.
Land buyers agreement is that's in the other petition.
Lordship. The first agreement is at page 49, your lordship.
Block C
Item
always remains with the landowner, even in the original agreement. Therefore, nothing changes, your lordship. There is no change. There's no transfer of ownership. So the bifurcation that the department is talking about is only on the land because of a construction of a common wall. If that's the situation, I went to the extent to say that I'm ready to break that also.
No, Mr. Khan, question is about the NOC.
Right. Was a change required in terms of the fact that there has been never change of ownership? There's no bifurcation in the land, with all due respect.
That is where.
That is why JMD had gone wrong to say that you have bifurcated. There's no bifurcation. Land remains the same. C was always supposed to be with the landowner.
At this stage, we can issue notice only.
Lordship, your protect by OC is gone.
OC is gone.
Yes, Your
And
Lordship.
And
another-
the issue of OC has never been closed.
No, the
No,
problem
no.
now I face is, Your Lordship, I can't go and apply for it in terms of the letter they have issued in 24th of March. This is the impugned
We
letter.
cannot revive now.
No, they won't.
No, Lordship,
That has been cancelled and
no
come to
coercive
the,
step.
come to,
Lordship,
what
we are-
coercive step?
Lordship, if the OC is gone,
Come
next
to-
will be demolition.
Come to page 137 and 138.
Your Lordship is referring to which petition?
No, my petition.
Therefore, builder is directed to furnish revised occupancy certificate proposal on the basis of the revised plot area and revised.
So that's an
existing-
exercise, Your Lordship, which I have been imposed now to do
Lordship.
in the fact that circumstances that the NOC changes.
Lordship, it doesn't
Now,
say
why,
that. No, Lordship,
why?
Lordship,
All
page
these
140
require a detailed examination of facts. And some factual determination of factual fact. Disputes would fall for determination. Then why we should go into all this?
Lordship, there's a question of law. May I humbly submit?
I am not finding anything in law.
146, Your Lordship, page 146.
I am not
which is-
finding
which is
anything
what-
on law. These are all factual disputes between purchasers, builders and owners and the developer. 4 parties are in dispute. 4 parties are in dispute. As a result of this dispute, the flat owners might have suffered. That is one thing.
Yes.
But I am not giving anything to
The builder.
builder as well as the owner.
No, I am not here seeking a relief. All I'm saying, Your Lordships, is that my permission that I wanted to apply is
Then
now.
why, tell me, both of you, why this cannot be adjudicated by the appellate forum?
Lordship, may I?
Appellate forum is because some factual disputes, even if we accept that there is a point of law involved, whether,
I can still explore it. I do not know about this thing.
why, Mr. Nayak?
Because this is anyway
Why you have not
supposed to
come
be-
up with the,
They will have to anyway.
if the jurisdictional district judge is the appellate authority
I agree.
to
But it-
hear and decide appeal against orders of the ZMD.
Right.
And if that authority is fully empowered to go into the factual determination,
With all due respect, whether the bifurcation could be decided by them.
Why
Because the
not?
That is the problem.
That's the
Lordship.
problem, Lordship, we
Page
face.
he is
146.
the appellate authority. He is the appellate. Do you think it is your submission that appellate authority cannot go into the point of law?
No, I'm saying the bifurcation. The bifurcation, for whether the NOC would have been to be applied, could have been a question in regards to facts, could have been decided. Now this already stands decided. They are saying it has been bifurcated, land stands divided. So I lose the FAR in regards to 1 and 2. C is anyway in regards
What
to.
is appeal?
No, I agree.
What
But
is
whether this
appeal?
bifurcation, if your lordship protects me to the fact that the bifurcation will be a subject matter, then I might please still go back before that.
Yes, Your Lordship.
Otherwise, I can't go and apply. My problem is today I can't even apply for the NOC, which now stands cancelled.
Now, why is power given to the appellate authority under section 72 and procedure of working of the appellate authority under section 73? And if the district judge is the appellate authority, then why should we go into all these aspects, subject to confirmation by Mr. Nayak, whether jurisdictional
I'll leave it to your
district judge is the appellate authority or not, and what kind of powers he has been given, what is the notification?
Yes, that so far as law is concerned, Lordship, it is provided. But whether that notification is issued or not, that instruction.
Because in one case I have found, and I have, because parties have come with the notification, now I don't know.
That is there.
Nobody has faced
but-
for me, but the matter was relegated to the district judge.
If my lawyer can come back, if he says it's
And there is a period of 1 month. So
there's
that
a number 2.
That
protect
can be
us from
counted.
limitation.
This is a
That-
notification
that
of
can be-
2022, Lord. Your order was of 2022, Lord.
No, this order?
This is 22 order,
Yes, 1911, 2022.
1911.
That page 130.
Six.
Oh, No, the appellate authority may, however, in its discretion condone such delay in filing appeal for sufficient reasons.
Yes, there is a provision in the last.
And not like the tax laws that within only he can condone. Because all these are factual determination.
Lordship, may I say 5 minutes? Why I am here? Lordship, page 146. That is what actually bothers us as flat owners more than anything else.
146.
146. That's the final and the last impugned letter.
Okay.
May I read, Your Lordship?
Yes.
With reference to the above, I would like to state the following. On the basis of MOU between Rabha, that is the owners, and Kesliwal, that is the builders, the land was transferred to the landowner. This is wrong. You cannot transfer ownership what you don't have. The builders never had ownership. The landowners under the schedule, under the agreement, always had, they have the development rights subject to rights of sale. So when the sale happened, then ownership transfers. So this is first wrong. Land was transferred to the landowner on which block C is constructed by the landowner. Therefore, the landowner only can apply for occupation certificate. I humbly submit this is wrong.
Yes, I am moving.
My problem is this. Further, based on the MOU.
Where is this MOU? All
It's
this
there in my petition. Your
3/7/2015.
Lordship. Your Lordship,
Yes. First, your lordship should have to see the first, the development agreement is page.
No, no,
65.
C7 2015, where is that?
of my petition, 123. 123. Lordship, the MOU does nothing. The MOU only says that its exact permission is block A, you build G+6, block B, G+6, and block C is G+4, and everything should be residential. That is the only NOC. NOC is confined to that. GMDA has no business figuring out who construct, how many employers constructing, and whose money. This MOU, your lordship, may kindly see, page paragraph 2. It only says that, lordship, may I just take 1 minute? The original development
All
plan.
these things been brought to the notice of the GMDA at that point of time.
Lordship, Lordship, according to law, it is not necessary. Lordship, GMDA is concerned
Not
with what?
necessary. Come to page 25, section 25.
Yes, your lordship, section 25.
Come to section.
No, section 25 is done. Yes, your lordship, section 25. Yes, your lordship. May I read? Clause 1. Any person or body intending to carry out any development on any land shall make an application in writing to GMDA for permission in such form and containing such particulars accompanied by such documents as may be prescribed. So any person or body intending to, it doesn't say owner. Now, what is important is this, clause 2 and what follows. What are they concerned with? Each application, such application shall be accompanied by a plan drawn to scale showing actual dimensions of the parcel of the land and the building to be built on, the site, the position of the building to be erected, in alteration and in case of alteration in the use or structure of the building or land, and the nature and extent of such alteration. This is what GMDA is concerned with. What is the original plot? What is the width of the roads adjoining it? According to which they will decide
now
what the structure is.
As per the original development agreement, what are the common areas?
It's there, all there.
And
they remain the same. There's lordship, there is the
what are the common areas?
It's already
For the intending purchasers.
lordship, may I make a submission? Between the original.
I am making a query.
Yes, lordship. Lordship, page 105. He wants
What
to
are
see.
the
Yes.
enjoyment of common facilities that it is confined to the areas wherein building A and building B are to be constructed?
Yes, your lordship. Yes. The flats,
Block C
lordship,
was always with the owner.
Owner.
That's what I read in clause.
that is scheduled, lordship.
No, the permission,
Yes.
because just I gave the example that if the subsequent agreement had happened.
Right.
As a result, so far say plot number 2 is concerned, owner would have exclusive right and the building to be constructed thereon had to follow the bylaws, building bylaws of TMD or whatever bylaws are there. And so far, building A and B, building B are concerned. 3 persons are involved there: builder, owner, and the intending purchaser. Right?
Yeah.
These are the 3 parties in building A and building B. Purchaser and the builder, because of the subsequent agreement, would not have anything to do with plot number 2. But when originally plan was submitted before the GMD, the entire plan was submitted. This is the building. Was it not your duty to bring to the notice of the GMDA that these are the subsequent development? Yes, things can be rectified. I am not saying that you
agree.
don't have any right.
I just answer your lordship's queries. The developer agreement that was executed in 2005, whatever the terms, conditions, whatever was agreed, remained the same. 2015 was only a change of hand to construct. That's it. Please follow the developer's agreement. A, B to you, C to the owner, B, do it, everything in terms of the same, because we could not have changed it. If I had changed the terms and condition, I would have had to go back to GMDA, because then the nature of the NOC would have changed.
Then
Lordship,
That's what I'm
it
saying.
is a situation like on the very first day, filing a writ petition, you take the interim prayer granted. And after some time, you withdraw the writ petition without telling the court that one interim order is operating. Lordship will see the page 58 of the second writ petition, the NOC, whom it was granted, Lordship. It was granted to the builder, Otis Infrastructure. Lordship would see there 3 blocks, block A and B, handwritten, Lordship, just above setback. Ground floor, ground plus 6, and block B, block C, G plus 4. Setback is clearly mentioned there, Lordship. And this floor ratio, Lordship, plot area plus height of the building. It was decided on the basis of the entire plot. Main road was considered, Lordship, not the byland. Now they are using the byland. One wall has been constructed in between, Lordship, between the 2 plots. So this setback, Lordship, has already been violated. So occupancy certificate will depend only upon fulfillment of the conditions in the NOC. That will be my basic submission, Lordship. If these conditions are not fulfilled, occupancy certificate cannot be granted.
And Lordship, that is where the flat owners come in. Now they want us to apply on the basis that is, no, where I am absolutely prejudiced. They want us to, now they first say that you're bifurcating. Then they say the builder says there's no bifurcation. Now if the builder applies by bifurcation, then block A and B does not have an FAR for 6. So my 5th floor gets demolished. And that is which is why, Your Lordship, I've come to you under 226. That at the end of it, because of a violation of 1 floor, on the contention of the builder that there is no bifurcation. There is no bifurcation of ownership. So if there's no bifurcation of ownership and only a...
Okay, if some act of demolition is initiated, you come to that, we'll issue notice at this stage. Then we are not going into all these disputes, factual disputes right now. Since you feel that
grant me
the
liberty.
appellate forum is not an efficacious, adequate forum, then we'll issue notice.
Lordship,
At a later point of time, we find out that the factual disputes are involved. Then again, it will be relegated hard MS.
G. Goswami.
G. Goswami. Learned counsel for the petitioner. Mr. Nayak, you can appear for one also?
GDD, yes, Lordship.
Okay. Mr. P. Nayak. Learned Standing Council, ZDD,
as well as GMDA.
GMDA,
GMC.
and GMC.
One
For
to
the
six.
respondent number
1 to 6 in the first case.
1 to 6. What is 7, 8?
Nirupama Rabha is the plot
Okay.
owner, Lordship.
And Mr. Fukon, you can appear for 9. Then notice can be dispensed with.
Yes.
Okay. So Mr. R.B. Fukon, Learned Council has also entered appearance on behalf of the respondent number 9. The petitioners who are purchasers of flat in a multi-storage apartment complex named as Nirupama Nivas have approached this court. Agreed by the cancellation of earlier proposal submitted by the builder. Agreed by the cancellation of the earlier proposal submitted by the builder of the said multi-story complex within bracket respondent number 9 by the respondents GMD authorities. Full stop. The petitioners are also aggrieved by the direction contained in an order dated 14/12/2022 passed by the respondent number 4, whereby the builder within bracket respondent number 9 has been directed to furnish a revised proposal for occupancy certificate on the basis of the revised plot area, on the basis of the alleged revised plot area and revised existing access from the secondary road based on applicable norms. Full stop. The MS Goswami Learned Council for the petitioners has contended that 3 buildings, that is building A, building B, and building C, have been constructed exactly in conformity with the NOC, no objection certificate, granted for construction by the respondent GMDA on 6/11/2007, and as such, the decision contained in the impugn order dated 14/12/2022 is erroneous. Full stop. We are just recording for the minimum facts for issuance of notice only. We are not hearing it finally. MS Goswami has further contended that the petitioners, as purchaser of flat, are entitled for occupancy certificate as approved by the respondent GMD authorities earlier by the order dated what is 6/4/2022 within bracket annexer 11. A annex it was just 14/12/2022 আছিল না সেইটো annexer 16. Mr. Nayak, Learned pending counsel, so and so, so and so, so and so. Appearing for the respondents, state respondents, respondent number 1 to 6 has submitted that there is deviation from the NOC, they're rated so and so. And as such, no interference is called for in respect of the impugn order in 14/12/2022. He has further submitted that the order, impugn order dated 14/12/2022 is an appealable order, and an appellate, a remedy of appeal is available to the petitioners under section 71 of the ZMD Act 1985. So for the matter would require further consideration. Issue notice returnable on the third review for as so and so and appeared, accepted. No formal notice, extra copies within 2 working days. A petitioner shall take state for service of notice upon the respondent number 7, 8, and 10 by registered post with AD within 3 working days. It is. You have come quite late. It is observed that in the event, there is the respondent authorities contemplate any action which, according to the petitioners, appear to be adverse for them, the petitioners will be liberty to approach this court by way of appropriate pleading. If something happens, then you are at liberty. Suppose demolition, because otherwise you have come quite late. And what about your case?
March 23 from
Mr. Fukun, what is your case? Same order. You have impugned the same order. Court will provide occupancy certificate.
I would only request that.
Mr. Fukun, you have no business with Block C.
Yes.
Come to page 40.
No, I don't say I don't have no business. I said initially it was all under one.
Absolutely no business. Now, absolutely no business.
Subsequently, I.
Since 2015,
Yes.
you have absolutely no business
Absolutely right.
with Block C. But
Absolutely
you are asking for a mandamus in respect of Block C also.
All I'm saying is.
This appears to be
No,
something.
all I'm saying, your lordship is.
Heard Mr. R.B. Fukun.
Plan, even if I want, for A and B also, because of the demarcation, that's why difficult.
Your prayer at page 41. Court will provide occupancy certificate for building, namely Block A, Block B, Block C. You cannot.
It's not transferable. NOC cannot be transferred.
You cannot
With all due respect-
play hide and seek with the court.
No, I'm not, with all due respect. All I'm saying is that the NOC still remains the same. There's no bifurcation, there's no transfer of ownership. Therefore, the building,
Petitioner has approached this court seeking inter alia a direction in nature of mandamus to the respondent authorities, more particularly the respondent ZMD authorities, to provide occupancy certificate for buildings named as Block A, Block B, Block C, constructed over a plot of land measuring so and so, pair 1 of LPD. Without prayer Z Paliki, the petitioner has also assailed a so-called notice has also inter alia assailed. What is 14? An order dated 14/12/2000. 14/12/2022. Annex 11. Which was passed after issuance of a so-called notice dated 19/11/2022.
Yes.
Comma, and a letter dated 24/3/2023 within bracket and Excel 13. বাকিখিনি সেম লিখে দিব গোস্বামীখিনি নালাগে নায়কখিনি লিখে দিব same date returnable as Mr. P নায়ক লিখিব pending council GDD GMDA
James,
GMC 1 to 6. Petitioner shall take steps for service of notice under as per number 7 to 9 by registered for KD within 3 months. Same observation. Listen what happened. Take it down.
Item number 3.
Yes, madam.
Proceed with some other development.
Okay, Mohammed, yes, or something. Right? Tuesday. No, no, no. We're not keeping it. Either this way or that way. We have heard it many times. Mr. Kyle? Not. On the prayer of MS so-and-so, MS? S. Sharma, Learned Council, appearing for Mr. Didas, Learned Senior Council for the petition, has submitted that. Mr. Das has some personal difficulty today and has thus paid for listing of the case on another date. So stop Mr. S.C. Kyle and Standing Council GST for the respond number 2 and 3 is present. So stop. List the case on 23/1 till the interim order passed earlier. On 4/1/2024 shall continue till the next date of. MS K. Pukan.
Yes.
Okay, K. Pukan, Learned Central Government Council for the respond number 1 and SC CAT. Yes, where is Mr. Kyle? Huh? There is another standing council. So good.
One junior council is there, public copy has been served on him, but not to me.
Oh. Okay, then Wednesday, if have a copy.
We have already served the copy. Yes, the registration was cancelled, Lord.
No, I understood. Kyle is not appearing in this case.
Copy has not been served on me, that is difficult. The 2 matter may kindly be taken.
No, it will be very difficult. Similar order, but at least the presence of the council should be there. If he may come up with something new. Not to. Heard Mr. S.K. Agarwal, Learned Council for the petition. Mr. S.K. Agarwal, Learned Council for the petition is present. No, we are. too heavy tomorrow. 22 or 20? 23 did you? Okay, on Tuesday. Huh? 19 to 29. Then on 30. First February. Okay. As the learned council, standing council GST for the respondents is found absent today. On call, release the case on 1st of February 2023 in the motion. Good. Item number 21. Yes.
And there was an order issued by the DMC authority on 12/1 during the pendency of the
Pendency of the?
while after filing of this requisition. What they have done, my lord, this room was not sent for from province. It was released from the outcome.
Okay.
When
it has become impulsive. Then it has become impulsive.
No, then allotment has not, position has not been given today, my lord.
Mr. Kotogi,
Yes.
come to page 32.
Yes, sir.
Paragraph 4.
Yes.
First two line.
Relinquishment.
Yeah.
That is there, my lord. That, my application is there. I can close the application.
If you have relinquished the claim
Relinquish was subject
of the shop in the first floor,
to, but relinquish subject to allotment in the ground floor.
This relinquish was done in 2008.
relinquish is done on 2016,
No.
unless this observation
Yeah, I understand.
is reviewed. Your thing is closed.
Actually, my application, your lordship, my filing, the application that I filed before the GST.
Prima facie, I have not found any merit to enter in this request.
I understand. But since
Because of this observation by the division mans, because you have got two shops in the ground floor.
Yes.
Third shop you were allotted on the first floor.
Yes.
Then litigation ensued. Then what is the observation by the single judge? Please.
that I'm not entitled.
Huh?
Right. For third shop.
Third shop you are not entitled, right? Then this paragraph 4, relinquished. Then come to the final observation by the division bench,
Yes, ma'am.
right?
Yes,
Is
ma'am.
wholly unreasonable. We find no good ground to interfere with the impugn order. If the single judge has said that you are not entitled for the third shop, and division bench has affirmed
Yes.
with the observation that you have relinquished your claim in respect of the third floor. Now, what is the area or what is the hole through which we can enter into, or you can enter into now?
That has happened because of the order passed by the direct commissioner, my lord, way back in 2008.
That has been judicially determined.
Yeah, I
Show me
understand.
please show me the judgment of the learned single judge.
And in review also it was dismissed.
So, that is why, and 3 forum, single judge, division bench, and review. In at 3 forums, you have lost.
Yes.
And there is a clear finding that third shop, which was allotted the petition in the first floor, was relinquished by him. Right?
But there was an application, that application.
Whatever, you have relinquished.
It was actually subject to.
Show me the judgment of the learned single judge.
That also has come to the same time.
That's what.
That relinquishment.
Then how can you revive?
I understand, my lord, but that's what because of my own application.
So we are not, we do not want to keep a writ petition pending, which has the possibility of blocking other writ petitions. When we find expressly There is absolutely no merit.
Understand, my lord. But now since.
Why should we issue notice?
No, I understand, my lord. Since they have already.
Can you give me the judgment of the learned single judge or I'll. Mr. Bora, is there anything to entertain here?
Nothing, my lord. He relinquished it in 2018. Now, when we want to act on it, now he has realized. He's sitting over the matter and not thereafter in 2023, after almost more than 15 years. He
So
suddenly
with the
has woken up.
learned single judge order?
Yes, I'm just- Actually, if they consider it, my lord, because since.
Trace application is different.
Yes, that's, I'm like trying to phrase application for.
No, you are trying to block the auction.
No, they have now.
Let him participate in the auction.
No,
Part they have already.
no, we are thinking of imposing cost. That is why we are examining it.
That we are not, we are not.
So we are thinking of
Yes, number
imposing cost.
Yes, number
Well,
Not only not entertaining, we like to explore the area so that either the exchequer of this court or the state exchequer can be benefited.
I'm not basically.
WPC number 3514.
We have to find ways and means.
3514 2010.
351. This will be otherwise abuse of the process.
I'm not pressing that. Even since they have already considered my prayer for re-auction, my lord. That's fine. Actually, basically for re-auction, we have.
Now he
We
realized
simply
that
say,
after COVID, business is rising. That's why he came. That's the pleading, my lord.
I have seen it. Since he is withdrawing it, had it been argued on merit, we could have done it.
And already my.
We will not observe anything. Mr. Kotoki, P. Kotoki, Learned Counsel for the petition, has submitted that the petitioner wants to withdraw the petition. Mr. S. Bora, Learned Standing Counsel, GMC,
I am replying for all the respondents.
for all the respondents, is in attendance and has no objection to the state prayer for withdrawal. In view of the above submission made by Mr. Kotoki, Learned Counsel for the petitioner, the petition is dismissed on withdrawal.
Because my purpose was because they have already.
We will not observe anything.
Item number 22.
This is same SK Agarwal. Huh? I don't know. Same day then. Hey, Agor to lista. Item number 19 or lista. Oh, material.
Item number 1. Considered earlier occasion hardly matter. My submission is based on a very short temper. So what I was trying to submit was that in fact particular procedure is laid down on the CRPC for obtaining
CRPC
or evidence when it is outside in fact India. Now 166A is the relevant provision which says that if such evidence is necessary, the investigating officer would approach the magistrate, and therefore an order of the magistrate is a silent one for issuance of the letter of request.
But he did not do so. He completed the investigation by another means. Some documents he had collected. On the basis of that, he has submitted the SARS under 1673 CRPC. If it is a warrant procedure case, notice has been issued. Your appearance is called for. Now, two options are available to you. Seeking quashing of the charge sheet and the criminal proceeding, or to say that the basis on which the charge sheet has been submitted, that is more particularly the letter of the Bangladeshi High Commission. That cannot be taken as a legal evidence. Then that option is available to you under 239, 240 CRPC for discharge. Otherwise, we have to examine the legality and acceptability, admissibility of the document of the Bangladeshi High Commission in a 482.
Without going to that, even without going to that aspect, what I'm trying to say, my lord, for the time being, I forego my claim in respect of those respondents which are outside India and in respect of the report which has been submitted by Bangladesh, my lord. Now, what I'm trying to say, apparently, my lord, if your lordship comes to the FIR and the charge sheet, your lordship will find that the entire basis of the charge sheet and FIR is only that report.
Right.
Yes.
That document.
Yes.
Now,
if your
second,
lordship holds, my lord,
secondly, that is some connected issue. Now, you have based your prayer on the basis of some documents which you have collected from some official from offices of Bangladesh government
I will not rely on that.
notarized, which you cannot rely on
Rely.
in a petition under 482. Those letters gone. Law is settled. You cannot rely on. That can be done only at the proper stage in a trial. At the stage of 239, 240 or at the stage of 482. It is only the charge sheet and the records of the case on which you can seek quashing or discharge. So far as at the stage of 226 or 482 is concerned, the admissibility of a particular document, unless it is of unimpeachable character, cannot be gone into. But at the stage of 239 or 240, it can be gone into. Law is also settled. So we have to see that whether this document, because your documents are not going into, we are not going into. We are, those are, we cannot treat at this stage unless it is of unimpeachable
There are some
character.
judgment, my lord, where we say of the Supreme Court that the evidence of the defense also can be considered. But I'm not on that.
Yes, that is the proposition.
Yes.
Yes, can be considered.
By the High Court.
But yes, that is why I am saying. But it has to be of unimpeachable character.
That might
Your documents. I can hold the opinion that this cannot be considered to be of unimpeachable character, documents of unimpeachable character, because these are documents which are notarized, which you have placed. And the state notarized document cannot be at this stage
Correct.
categorized as a documents of unimpeachable character. These documents are gone.
I'm not seeking an opinion in respect of those.
So,
Yes.
well, no, that is why I'm limiting it, because if you going to submit it, it will take time. So I'm cutting short. Only thing is that the document of the Bangladesh High Commission or Consulate Office of this, they have made a finding that your documents are fake.
I understood, my lord. Can it be this way? Lordship will issue notice. In the meantime, the records may be called for, your lordship will examine.
No. You can issue notice or very short for disposal only for the state respondents. I am somewhat speaking my mind. We are not broadening the scope of 226 in exercising the criminal jurisdiction by issuing notice to any other, except to be represented by public prosecutor.
I may switch over to 482. Perhaps, my lord, my scope would be broadened. So, my lord, in that case,
Because we are not issuing notice to other respondents, we are only issuing notice to the public prosecutor.
in respect of others, my lord, the authorities, my lord, outside India, I'm also foregoing my claim in respect of them. But others, my lord, so far as state respondents are concerned, That part your lordship.
State respondents can be represented by, very well by Mr. Public Prosecutor. We can issue notice
But what my lord I'm
at
on,
this stage,
Yes.
not in the motion stage.
what I'm on, my lord, applying bhajan law, paragraph my lord, this, more particularly.
Which one?
Number 3, bhajan law case. my lord.
Bhajan Lal.
Yes. Now, it says that prima facie, my lord, when there is no material, on the basis of the controversial, my lord, uncontroverted, my lord, allegations, my lord, and the materials, my lord, if there no, my lord, offense, my lord, is affected, then perhaps some interim order, my lord, is.
No, we are issuing short notice by 3 days.
One more thing, Lordship, 482, he hasn't applied the provision of 482, Lordship. He hasn't applied.
Bhajan Lal, paragraph
482.
135 says 226/482.
And Lordship, as this case is, Lordship,
Paragraph 135 or 105?
101.
101.
Lordship has at least pointed out, Lordship, SARS has not yet been framed, Lordship, and he has the scope to of hearing on that SARS, Lordship, issuing.
Because
that,
this
Lordship.
IO has based his entire case on the basis of that document.
That document.
And question is about legality, admissibility of that document to quash your proceeding, whether in 482 or 226. Show me, Bhajan Lal says that legality of admissibility of any document can be gone into.
May I?
These are the province of the trial court.
In fact,
Anyway, we are issuing notice, we'll examine. But very short notice.
kind of interim order.
No, your date is? Date of appearance. I think still a long. Who is the summon?
3-2, my lord.
3-2.
Yes, 3-2.
Okay, we are putting it either on 25 or 30. Heard Mr. S.K. Talukdar, learned counsel for the petitioners. And who near with here? Thomas. And Mr. P.S. Locker, learned additional public prosecutor, representing the respondent state of Assam authorities, that is respondent number 1, sorry, 2, 3, 4, 5, 6, 7, 8, 9. Full stop. The petitioners have instituted an instant petition under Article 226 of the Constitution of India, seeking inter alia crossing of the criminal proceedings of PRC case number 727/2023, presently pending before the court of learned judicial magistrate, first class, Hojai, Sankardev Nagar. PRC case number reply arising out of ZR case number 2215/2022. Where Mr. Talukdar, learned counsel for the petitioners, have submitted that the investigating authority, while initiating and during the course of the proceedings investigation of Lanka Police Station case number 512/2022, and did not adhere to the provisions contained in section 166A of the Code of Criminal Procedure 1973. So Ms. Talukdar has contended that the provisions contained in section 166A, CRPC is mandatory in nature. Full stop. But the investigating authority, merely on the basis of a document dated 15/12/2022 of the what is this full form, Mr. Page 52, that something is missing. No, the top part. High Commission of Bangladesh, what is the word?
Assistant High Commissioner.
Okay. Or the assistant High Commission of Bangladesh, Guwahati, Assam.
The subsequent find from the boarding fund, the Assistant High Commissioner of the
Assistant High Commission of Bangladesh. Office of the Assistant High Commission of Bangladesh at Guwahati. Has submitted a charge sheet, being charge sheet number 44/2023 on
resulted the FIR as well as
22/8/2023.
FIR.
He has submitted that the finding contained in the said document dated 15/12/2022 that the documents of the alleged accused person against whom the petitioner had brought the allegation as a person having Bangladesh citizenship or dual citizenship were fake or fabricated is clearly unsustainable.
Not say take off fabricated. It says not report.
No, underline. We are only issuing notice. Could not be traced and hence the opinion that those documents were found to be fake or fabricated is clearly unsustainable in law. Having regard to the contentions raised and the relief sought, this court is of the considered view, at this stage, that notices are not required to be issued in respect of the other respondents, except the respondent authorities in the state of Assam, which are represented, except the respondent authorities, that is respondent number 2 to so and so, represented by Mr. Lawker and an additional public prosecutor. The notice is made notice is issued returnable on 25. 29 motion days, it will be difficult to dispose of. Okay. 30. 1/2023. An endeavor will be made to consider for final consideration of the repetition on the returnable date.
Madam,
My lord, I'm praying for a little accommodation, my lord. Mr. Dasgupta is on legs in court number 7, my lord. After some time, my lord, if your lordship can, he'll just come, my lord. He's on legs, my lord.
I cannot buy. Here we go. Lordship, matter pertains to the option of spread which is
Okay. Oxon.
Well, this
Okay.
reflects the whole.
Okay, then let me come back after 2-3 minutes. Then we can see. Yes, Mr. Dutt, 2-3 minutes. Third key.
Before, that's a brief here, the materials that were worth of exponent number 1.3, which is antecedent contract to be disposed of to an auction by the exponent number 4.
1, 2, and 3.
1, 2, and 3.
Basically, Power Grid Corporation.
Power Grid Corporation. Power Grid Corporation had some capital. They entrusted the responsibility to MSC to an auction process, dispose of them. So the MSC, I am is a registered user of MSC, where he had participated in the auction process earlier as well. So this tender notice was issued and it should page 30.
What is the date?
That date is was 21 to 20.
No, date of the tender notice, any idea? Okay. Okay. Any date mentioned?
The date tender the auction notice is 17 to 22.
17 to
22.
Okay, 17 to 22. It is by MSTC.
MSTC.
Meaning date.
Opening date and time.
21st February.
21st February, 11 AM was the time, and the closing date and time as 16:30. 4:30 was the closing. The lot was mentioned, the lot item was lot is mentioned, quantity is mentioned.
Code where?
It is at page 31.
What is ACSR? ACSR.
It's a conductor, it's a ACSR.
What is the full form?
Conductor. So these are
One minute.
aluminum ACSR conductor for overhead.
ACSR. ACSR.
ACSR conductor.
Lapwing, I don't understand. ACSR, let us see.
Here, the 3D
ACSR key. Let us read that column.
ACSR conductor.
Okay. Aluminum conductor, steel reinforced. Aluminum conductor,
Steel
reinforced. So both aluminum and steel. Because these are technical jargons, so we have to understand at least. Okay, ACSR Lapwing conductor. Oh, okay, read as per list attached.
As per list attached. There was a list attached.
Click here for lot details, contact person. The quantity
Is purely
is indicated against the material.
and without
Your
any
unit of measurement is lot are purely indicative and without any guarantee, and the seller
The shall not entertain any complaint from the buyer for any deficiency in quantity or for recovery of the whole or part of the money or any loss of profit, oblique interest, oblique damages, and otherwise.
So tentative quantities,
1368.66
1368.60.
metric ton.
What is 18.0?
18.0 is
GST.
GST.
Yes. And location,
Location is
Bishwanath Sarigili.
Vishwanath
B
Sarigili.
Pukuri, one store.
And
Okay,
important part is pre-bid EMD amount.
okay.
Pre-bid EMD amount was
34 lakh something.
34 lakhs 49,000 is the pre-bid EMD.
Okay, come to page 32.
Payment, LC contractor transaction entered into the buyer bidder out of the auction shall be governed by the integrity pact available on our website. Payment term, pre-bid amount. In order to participate in bidding for lots which require pre-bid EMD, the bidder is required to have sufficient balance in EMD wallet provided to the bidder for the purpose. A bidder can add money to its EMD wallet anytime through its e-payment mode only and by following the pay pre-bid EMD provided in the dashboard. Bidders in their own interest are advised to keep sufficient balance in their EMD amount. Pausing hereby, bidders in their own interest are advised to keep sufficient balance in their EMD wallet, pre-EMD wallet, that is 34 lakhs was the minimum amount which was endorsed. To bid in any auction and avoid any last minute pickup. MSCC seller shall not be responsible for any delay in crediting of the money in the MSCC bank account due to any reason resulting in delay of updating of EMD wallet of the bidder. Procedure to deposit EMD. Bidders need to use Internet Explorer only. After successful login, will get 3 link steps at their home pages. Pay EMD, EMD refund request, EMD ledger. Pre-bid EMD must be paid by the bidder in global pre-bid wallet, NEFT RTGS to pay pre-bid EMD link only. For refunds, bidders need to request to the EMD refund request link only. Refund to bidder as per online request will be processed from the HO on the next working day. This pre-bid EMD can not be used for any other purpose. So, pausing here, the pre-bid amount that was given was of 34 lakhs 49,000 was the pre-bid amount. Why is this amount given? Because here 10% EMD has been asked at its lowest at point number 2. If we directly come to point number 2, I want to draw a correlation between the pre-bid amount and the
No, read the entirety, then let us continue.
Okay. For any queries, next part, bidders are advised that pre-bid EMD should be deposited at least 1 day prior to the date of the auction. Pre-bid EMD shall be refunded adjacent with the EMD oblique remaining sale value with applicable taxes and duties received within due date, failing which the pre-bid EMD stands automatically forfeited. In order to participate in bidding for lots which require pre-bid EMD, the bidder is required to have sufficient balance in the EMD wallet provided to the bidder for the purpose. A bidder can add money to its EMD wallet anytime through e-payment mode only and by following the link pay pre-bid EMD provided in the dashboard. Bidders in their own interest are advised to keep sufficient balance in the EMD wallet to bid in any auction and avoid any last minute pickup. MSCC oblique seller shall not be responsible for any delay in crediting the money of the crediting of the money in the MSCC bank account due to reasons resulting in the delay of updating of the EMD wallet of the bidder. Number 2, EMD. The bidder shall submit earnest money deposit MSCC to payment gateway within 7 days from the date of e-auction of the accepted lot. The EMD shall be 10% of the net sale value quoted, excluding taxes for the lot sold. For STA lots, the bidder shall submit earnest money at MSC through e-payment gateway within 7 days from the date of acceptance.
What is STA?
STA would be that I am not sure. STA would be. This is not our bill is not with regarding STA would be.
Okay.
The EMD shall be adjustable towards the material value only after the receipt of the balance material value of the last installment in case of installment payment, along with the applicable duties and taxes, failing which the EMD shall be automatically forfeited. In normal circumstances, EMD should not be accepted beyond the period stated above. However, in exceptional cases, EMD can be accepted along with full balance, material value, and taxes thereon, and within time limit of balance payment. However, this does not confer any right to the bidder to make late payment of EMD, and MSTC seller reserves the right to accept or not to accept the payment. No further extension without penalty will be allowed under any circumstances. It should be noted that a failure to submit EMD within the above stipulated time will result in automatic deactivation of the buyer's login from MSTC system for a minimum period of 6 months. Thus, the bidder shall be debarred from participation in any auction being conducted by MSTC for a minimum period of 3 for hazardous materials, /6 for all other materials, 3/6 months, and thereafter deactivation penalty will be imposed as per policy. In case of failure to pay EMD for pre-bid EMD loss within the stipulated period, such pre-bid EMD will be forfeited and user account of buyer will not be deactivated. In case of failure of pre-bid EMD of the EMD, the forfeited pre-bid EMD shall be treated as inclusive of GST amount at the applicable rate. Balance payment. Buyer, bidder shall
EMD loss.
deposit the material value to the seller principal directly.
Read first again. In case of failure,
In case of failure to pay
pay
EMD
EMD for
pre-bid EMD loss within stipulated period, such pre-bid EMD will be forfeited and the user of the buyer will not be deactivated. In case of forfeiture of pre-bid EMD, the forfeited pre-bid EMD amount shall be treated as inclusive of GST amount at the applicable rate. Balance payment. Buyer, bidder will have to deposit the material value to the seller principal directly. The cost of each lot of material along with taxes and duties must be paid by the buyer in one single installment within 15 days from the date of acceptance letter by the MSTC, including the date of issuance. The details of the mode and payment of amount of payment towards the balance materials value favoring the seller MSTC. Service charges shall be clearly specified in the sale order. Service charge payment should be made in MSTC Guwahati account. The pay should select Guwahati region be dropped down. RTGS NEFT payment link for the payment in MSTC account is available in buyer's login. Bidders are requested to avoid last minute payment. The date on which the amount is reflected in MSTC account will be considered. Buyers are advised to keep buffer of at least 2 days to avoid transactional delays from the last date of payment. Click for payment guide. In all cases under any provincial law, local law shall be applicable by the purchaser exclusive of the sale value of the seller principal. Another tax due in respect of the sale under any law for the time being in force shall be payable by the purchaser in addition to the price.
so it is a auction process where the condition precedent is there should be pre-bid EMD account.
Yes. And what I want.
Otherwise, you cannot enter into the
Yes.
auction process.
Yes, this page 40, I have given the pre-bid.
Page
40. This request to for transfer of fund by RTGS, Canara Bank. Remittance payment. Amount is 36, 61. 36 lakh 61,000. Now pausing here, Lord. In the auction notice,
what is the date of transfer?
Date of transfer is 19.
19/2.
That is 2017 was the auction notice. 21 was the date of opening of auction. 19/2 I have deposited. Now, what if the pre-bid amount as given by the authorities was 34 lakhs 49,000 was the pre-bid. In the auction notice, as I have read now, it is said that you can deposit more than that also, considering whatever the amount that you want to buy. That is the idea. That is the.
But minimum amount should be 34 lakhs.
I have not deposited 34 lakhs. I have deposited 36 lakhs.
Right.
Why I have deposited 36 lakhs? Because my mind was that if I have to purchase the amount, 10% of 30, if I go the reverse calculation, 3 crores would be the total value that I would like to purchase. 3 crores 60 lakh. Out of which 10% will be the EMD amount. So that once I am successful in the bid process, then this from pre-bid wallet it automatically goes to the EMD. That was the idea of 36 lakh. I would have deposited, had my idea being deposited, that I would have purchased, because I know that I can buy quantity.
We cannot enter into the mind of the bidder.
No, I'm not.
We are not entering into the, we are on the
I'm submitting.
process.
I'm submitting. Not Lordship. Why then? Why would I have not given more than that? When there is
Because it is the minimum.
minimum, I could have
30
given the minimum.
Because if 34 lakh something is not there in your pre-bid wallet,
Yes, sir.
then pre-bid EMD wallet, then you cannot take part in the auction process.
That is
It is
precisely,
pure and simple.
this is precisely my submission. When I know that I qualify for the race by giving an amount of 34 lakhs, I would have given because there is a difference of 2 lakhs. It is not even 1 rupee.
No,
I
condition is that to participate, you must have minimum 34 lakh in the pre-bid EMD wallet.
Yes, sir. That's what.
Otherwise,
I
there
am not-
cannot be any consideration because you cannot enter into that online auction process itself.
I'm not even eligible to
Not-
participate in the race.
not.
That is the thing.
Could not have been, if it is 33 lakhs, there could not have been any thing like institution of a repetition.
Now, Lordship, what I'm submitting, Lordship, to Lordship's consideration, that is, what is that here, when I'm in an auction process, what the auction process, the primary objective of a buyer would be how much can I pay? What is the limit that I can pay? And what is the lot I want? I wanted that lot, but I require that lot at a particular limit. That's an auction process. That's a bidding process. In a bidding process, there will be hundreds of buyers. When there are hundreds of buyers out there, every buyer will have a particular upper limit. So my upper limit, when I have deposited the pre-EMD amount of 36 lakhs, in my mind, my upper limit was already set. It was that could not have exceeded 3 crores.
It is your pleaded case.
That's what I have said. It's a pleaded case. Now, Lordship, going ahead on that thing, that's why I deposited the 36 lakhs. After that, I participated in the auction process. Now, in the auction process, on the last occasion, Lordship has posed the query to NHB. That's what was the amount, what was the earlier amount before I entered my amount? My amount of, because here the whole bone of contention started. I gave in my mind, I was thinking 20,001 rupee. I entered 2 lakh 1 rupee. So on the last occasion.
Are you literate or illiterate?
No, I'm.
How much academic qualification you have? Tell me.
Don't.
Because I suddenly remember there is something in the counter affidavit that it is not only in figure. This thing also appear in words.
No,
So that is why I am asking you what kind of literacy you have.
Lordship, what has happened is that he being now here, there is a question where he had done. No, Lordship, I am submitting here. There is a mistake. I'm not saying on the point that whether and whether it's not a thing that it's a bona fide mistake. When the amount is entered, Lordship, if the amount is entered, generally when amount is entered, it is always a comma is given out. Here, if the amount is written, here there is no comma. It's to 20,001. It happens, it can happen, which happened in this case.
If I remember correctly, that once a bidder enters a figure,
what happens is that there is a drop down. There has to be a reconfirmation. In the reconfirmation, you are not required to type again the number.
something.
Lordship, here that's there. I'll show it in the affidavit. I'll show you everything where it is. Here, once the amount is entered, then you have to press enter. And what happens is a reconfirmation is in words. The reconfirmation comes, everything comes, you are not required to re-enter. What I respectfully submit here, Lordship, is that when we enter, I'm just giving an example. When we are entering a password or resetting a password, their password always prompts twice. We have to re-enter the same thing twice. There is a reason and logic behind it. The reason and logic behind it is that once you enter the first password, the second password has to tally with the thing. The same way, had it been a case where he entered both on both occasions, this is not the case here. In both occasions, he did not enter 2 lakh. On the first occasion, he entered 20,001 rupees. He entered it, then he said 20,001, since he was entering it, he said 20,001, I'll buy this man. That was it. in his mind. Then when he entered it, then the pop-up came and the pop-up was just a confirmation. And after he entered this thing and when he just he thought that why is this
You want to buy at 20,000.
yeah, I wanted to buy at 20,000.
Okay, let us come to you have annexed some document.
Which I lodged before that.
AP, SC, SR, SC, SR, SC, SR.
These are the things which my client had.
Which was, which can be relatable, which rate can be relatable to the auction lot? There are many figures you have annexed page from page 49 to
My
page.
thing is, these are scrap materials. One particular thing could not be like there could be many things in between. That's what my client had put.
But none of the figure is very close to 20,000.
No, this is per kilo. That is
Ton,
20,000
convert it to ton, no issue. No issue, you convert into ton. Ton is what?
So this is
1,000.
1,000. So
1,000 kg, let us convert.
160 rupees per kilo.
SR, conductor, overhead, we don't know. Checking type. Which one is close to the same thing?
what-
SC, SR, conductor. Conductor? Reinforced. SC, SR, aluminum, round, or industry. Rivet. Conductor tank. You tell me you are the expert in aluminum scrap. Tell me, if not at least your client,
These are
which are, suppose 175 is converted into 1,000 kg, then it will be 1,75,000.
Percent.
Then the 225 is converted into 1,000 kg, it will be 2,25,000.
Percent. That is not scrap.
But tell me that these are not
These are not
figures
scrap.
which.
These figures are not market value. I am buying scrap.
Okay, then what happened?
Now, no, now when this auction was given 20,000 last occasion auction was query saying that before my thing was given, what was the other amount? The other amount, as per my information what has been given, was all less. The highest was I think 17,000. Or another person had given 12,000 or some 3 or 4 bidders had given.
Is it so?
The MSCC can say this to the effect. That is.
Is it so? Yes, Mr. Edas.
This was a specific query which was asked.
What was the previous bid prior to petitioner's bid?
For the information received from MSTC or if I am allowed to provide the document. EPS. 1,000 rupees. As per the document is provided by the MSTC.
When did you enter? Quoted?
I quoted.
At what time? That was also a query made by this court.
That would be also reflected there exactly.
my lord.
What
The
time?
type.
Time.
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 I would have it.
Time.
Hmm?
Bid time is 1327. 1320. As per the document.
You have stopped everybody. Because the first bid, because it is up to, it was.
I will show you what has happened subsequently. I may be allowed to clear this thing.
No, your thing I am examining, that is why we asked the timing. That was, your bid date was?
Bid date was 21.
This is forward auction. There are two things. One is reverse auction and the other is forward auction.
As you increase the price.
A reverse auction is basically in respect of construction work, right?
lower the amount,
Lower, it goes lower.
it goes higher.
Suppose estimated value is 1 crore for construction of a road. Then somebody says 1.1 crore. Next one says I can do it in 1 crore. Next one can say I can do it in 90 crore, 90 lakhs. Right? It is forward. It goes up. Rate goes up. So it started at the right 11:35.
11 was the opening time.
11 at 11:35, one bidder quoted 1 rupees. 1 rupee. Next one 99. It goes on,
It goes on.
increasing. Last one was 1000 at 11:27. It could have gone on increasing. At 11:27, 49 seconds, last bidder quoted 1000. 4 seconds later, 3 seconds. 3 seconds later, at 11:27:52, you quoted 2,01,000, 1 rupees. So, because of this rate quoted by you, everybody stopped bidding.
They could not have bid. They have
They were not contemplating, they were not contemplating to buy at any rate higher than what is in their mind, which you have just submitted.
Yes.
Once that rate is quoted and confirmed, everybody else who was sitting in the bidding, they withdraw themselves. No, it is not possible for me to buy at a rate higher than 2 lakh. Or we try at some other time. So you have stopped the bidding process at 11:27. Immediately after, 3 seconds later, from 1000. It was forward auction, it was going up, but you have made the benchmark so high
that the others could not participate.
others, nobody, Mr. Das or Mr. RJ Das or Mr. A Das, they would stop from participating if he is a prudent businessman. So others, prudent businessmen, they have withdrawn themselves. So you stuck at 2,01,000 at 11:27.
2,01,000.
That is the fact.
There is no denying that fact. I'm not
So-
denying that fact. What happened is that since that, as Lokship has
Now that I think that was auctioned later on also.
yes,
Let us see that.
that auction, that's what I am saying, Lordship. Now, just before going to that point, Lordship, here what happened is that since I was looking at it and there was no movement, I thought, I was actually, initially I was happy about it since I got it.
You had 5 hours to react.
Then when,
Even if after blocking, after putting out all the competition, you have gone so far ahead. In a marathon, you have almost crossed 42 kilometers. Others are at hardly at 2 kilometers, 3 kilometers. They have stopped running. You have put the race behind you. Is it not?
there is no dispute.
So now that is why that whether your rate, that is what was in your mind at that point of time, was 20,000. Was it a reasonable amount? Let us see the next auction for the same lot.
Which is found at, I have given in my next as well as I think
I think they somewhere it is there.
I have given in my affidavit as well.
Affidavit.
Additional affidavit, just filing.
Additional affidavit.
Lordship will find out the additional affidavit filed by the respondent number 123.
Respond number 1, 2, and 3.
Both the
Okay. Page, any idea?
118 here, as running page.
118.
In a checkbook.
118.
The letter.
1 minute, 1 minute. 114 bid history.
118, your lord,
118.
of the additional affidavit.
118 is an email.
That's what.
It's an
I have incorporated the option thing in my edition. Annexure 13.
If your lordship goes to page 119,
Your
the next page.
repetition,
Next page, your lord.
repetition, then affidavit in opposition,
119.
affidavit in opposition. Then affidavit in opposition by respondent number 4.
Page 119.
Additional affidavit
Yes, your lord, by 123.
by 123.
Yes, your lord, page 119. 118 is an email.
Now, what is 114?
114. 14. I don't need to eat this level.
114
bid history.
That
Bid
is what lordship. That is the correct. 114 is the second.
I am asking for 114.
The re-auction, my lord.
Re-auction. That is there also there in my affidavit.
The respondent 123 took plea of this honorable court to re-auction the scrap material.
Same material, lot 1,
material.
else AC,
Yes,
SR, Lepuik, conductor, Bishwanath.
Yes, your lord.
Vishwanath. So how do you connect this, your contemplated 20,000 with this bidding? It ended at 1,70,000. Is it nearer to 2 lakh or is it nearer to 20,000?
That is essentially my case law. Here, what, when I had participated in it, I would have gone maximum to 36,000.
That is different.
That is my.
I cannot read into your mind.
I'm not.
I am thinking pragmatically that what is the market value of this lot scrap materials, AC, SR. In the second round, it had gone up to 1,70,000 per metric ton. It had gone up from 1,69,000, if it is correct, in this bid history, and it ended at 1,70,000, which is nearer to 2 lakh rather than to 20,000, which was in your mind at the time of bidding. And what was the? And you bidded, you quoted the threat at 11:27, 52 seconds, right?
13.
Meaning thereby 5 hours was still left to end the bidding process, right? So it remains stagnant at 2,01,000 rupees from 11:27. So everything had come to your mind within that 5 hours and you reacted at 4:30.
There is no denial. What I-
Cannot be also. Cannot be also.
Some record. I am not denying.
Cannot be also.
Submitting lordship. Here, when I amounted. Here I have, there is a bona fide mistake from my side. Now, when there is a bona fide mistake, I am not saying there all this is a mistake. It clearly said and over telephone also I agree. Since there is a bona fide mistake to the defect. What I am saying is, lordship, I am giving an example. We are saying, even in penal, the mistakes, the degree of punishments are different. Here, I am willing to pay for the second auction because here there is no law.
Degree of punishment,
Here
degree of
the forfeiture of 34 lakhs is being at.
right.
That
It is why I had been giving you patient hearing on many occasions, only to find out if there is something which can be worked out, right?
I had given a.
Otherwise, things are in a bidding process because I had already indicated that in a tender process, it is auction process is part of the tender process. Negligent mistakes in bidding cannot be permitted to be corrected on the basis of equity.
Bona fide mistake, Patel.
Negligent mistake. It is not that 20,000 you carry comma, whatever, comma, full stop, whatever. You missed the item. But in figures, it popped up in later that 2,01,000 rupees. That is the bid amount. Then you also confirmed it. Right. Maybe you are in desperation. We don't know. We cannot go into that aspect. But this 2,01,000 rupees is nearer to the rate on the next bidding process. Not nearer to what 20,000. Had it been that was what I was trying to find out, but by no manner we can connect this amount part on rate of even if it is scam with 20,000. Had it been a mistake, yes, could definitely be a mistake. But that does not indicate by any stretch. That is what Mr. Das, that is what I tried to. And suppose this kind of default, it is clear, I think. Come to page. It is closed, I think. Bidding process was closed. So the necessary consequence is that you have to pay the full EMD within 7 days' time.
That can I submit document? Here is page 114 is taken. When I inform them, they will use the bona fide mistake at 4:30. Because here the new bidding process, again the new bidding process, the closing time was given at 4:30. But they continue till 21:95, 9:25. They continue. Had
It does not indicate from 114.
no, the time, bid time was
It does not indicate from 9:25.
9:25. So what I asked myself this question that MSCC ended relevant, okay, fine. Your process is there, then let us open the bidding. Let us see, let us keep opening the bidding. If nothing comes for some time or for some moment or some hour or two or something, that here they extended this pre-bid. This pre-bid was also this.
This pre-bid was
This
this
pre-auction
bidding
also-
process was open up to 4:30
Yes, pre-auction was also open up till 4:30, but they went till 9:25.
because there was close increase within short point of time. See the 114, 918, 918, 919, 920, 920, 925.
Below that, we don't know.
We
If it
don't
was
know.
4:30, if it was 4:30.
We don't know.
If it was 4:30, then for what?
We examined, we tried to examine you from the every perspective.
No, that I'm paying lordship for equity because here.
Equity, that is what equity.
Lordship,
It
here-
cannot be.
Here, there is no loss. to
Wait,
them. The loss to them would be per se the auction, the re-auction part which is there, and maybe a small penalty
We are not-
imposed for that thing. That is what I'm saying, lordship. At 34 lakhs.
If the thing is defined in the terms and conditions, in definite terms, there cannot be any departure in 226. How can they have laid down the terms and conditions? That pre-bid is a condition precedent amount in the wallet. That is, they have defined that 34 lakh something is the pre-bid amount, which is a condition precedent to participate in a auction process, which is forward auction. And started bidding. And next is that once it is confirmed, it is not that one. That is why I try to understand the process. To find out something that's whether it is a bona fide. But it is not bona fide. It is maybe a close to, it is maybe a case of negligence. Because it
Bona
popped
fide
up, because from there, it is carelessness. But that also, cannot be, we cannot reach to a conclusion because 20,000 is not a reasonable amount at all. Not a reason, not a king rate close to the actual rate. So that submission also cannot be accepted. That is why I asked you whether you are a literate person or not.
Someone has given.
Have you come up with say, yes, I am only class 4? Then it is a different thing altogether. But
No, Lordship,
having deposited 34 lakhs,
36 lakhs.
36 lakh,
I am.
you are a prudent businessman.
That's Lordship. Here, what I am.
Maybe you have calculated the
That is what I have calculated, and for based on
For
that,
that,
a penalty may be.
equity will not
imposed.
come.
A penalty may be imposed and maybe a.
Where is the scope? See, Mr. Das, if you come to page page 33. Because this is closed. Once closed cannot be, because you have ousted all other bidders by quoting that 2 lakh. In case of failure to pay EMD for pre-EMD lots within stipulated period as such pre-bid EMD will be forfeited.
What I am paying for equity on a.
In every tender process, that is a condition like this is incorporated always.
Yes, Lord. Here, what I am.
Let us see their stand.
Their stand is that.
Let
they
us
have-
read how the process starts.
My submission is that here no one is that would be at loss except for me. Because here the EMD, total EMD would be forfeited.
That cannot be also because you have taken
That's
me
my
one. I have
confusion.
read page 118. Had they been successful to sell the lot to you, they would have been richer by 4.1 crore. They have lost in the process.
Now question is when I'm not able, had I been in a position to buy the thing, I would have bought it. That is it.
Your the proposition you have advanced before the court that you were contemplating to quote 20,000. We tried from every angle to find out whether that was a reasonable explanation provided by the petitioner. But by no stretch we can find out that this is somewhat relatable to the per metric ton rate of AC SR lot. So it is very closer to the rate because that is why I asked. We tried to find out from every angle.
Here, what, Lordship, here what I.
No, we cannot hear more. Yes, Mr. Das.
My lord. And actually, first of all, my lord, I will draw your lordship attention to annexure. It is page 43, my lord, of the deed petition, my lord.
Page 43.
43. This was the letter written by the petitioner to us, my lord.
You can submit your reply for few minutes. I'll give you the permission. Yes.
Letter dated 21/2/2022, my lord, on the same date, my lord. With reference to your above referred e-auction floated on MSTC portal, I have participated in your state auction process. In this regard, I would like to inform you that while quoting my bid, due to typical error, mistakenly quoted rupees at 2 lakhs, 1 rupees, instead of my actual bid of rupees 20,001 rupees PMT for the said lot. Sir, the matter also communicated to MSTC office, Guwahati by mail, and also informed over telephone before closure of the auction, copy of the state attached here with my lord. That way, on this, in reply to this letter, my lord, that's about further, I will take your lordship to annexure 2 to my affidavit in opposition, my lord.
Okay, annexure 2.
Annexure 2, Roman 2, page 24. This is a reply to their letter, my lord.
Okay. Yes.
Dear Mr. Ursina, MSTC auction portal provides a completely automated, transparent and unbiased platform to the bidders to compete for buying auction items. Hence, it is the utmost responsibility of the bidder to be extremely cautious and sincere while bidding. Moreover, when a bidder quotes the amount, an auto pop-up generated by system asks the bidder to reconfirm the quotation amount. Given all these factors, it is irrelevant whether the bidder was done erroneously, intentionally or unintentionally, and once the bid is registered in the system, it will be treated as an established fact that the bidder is ready to pay that quoted amount, my lord. Before entering into the system, my lord, this the amount was confirmed whether this amount is quoted by him. That when the party confirm the amount, then it was entered in the system. Once the amount is entered in the system, there cannot be any variance, any change in the rate.
There is that figure somewhere it is mentioned.
Well,
some that not only in a figure, also in words.
Well,
somewhere it is mentioned.
Please, my lord.
Paragraph 8. The bid amount in figures but also in words, which is enough to stop a bidder from claiming committed by the petition, which is not bona fide.
MSTC.
So, paragraph 6 also of respond number 4.
MSTC.
Bidders get a message in form of a pop-up
Well,
displaying the bid amount in both words and figures. The bidder has to confirm in the system that they want to proceed with the bid amount. The bid is recorded in the system only after confirming the same.
Only after confirmation by the bidder, my lord, the figure is entered in the system, my lord.
And process is like that only, that once registered, the bid cannot be withdrawn or modified by sending email to MSTC, whether within live auction or after. That is their stand. That is their stand. Yes. Anything? What about the next auction process? Or let us see.
That is in additional affidavit, my lord, that annexure formula to my affidavit, my lord, page 118, my lord. Lordship has already, I think, about the actual loss suffered by the respondent, my lord.
Yes, they have also said
My lord.
similar kind of lot fetched a price of rupees 1,91,000.
Well,
they are saying, we are not expert, but they are saying that similar material, AC SR, Lapwing conductor via auction number so and so, 23rd February 2022. Ours is 21st February. Highest bid was 1,91,000.
91.
And total 48 number of bids were received in between 1,91,000 to 1,91,148. So had you quoted 1,90,000, there could have been some higher bidder. But you quoted very high.
Some lot went beyond 2 lakhs.
Is it? Where is that? Any idea? Come to that page 84, Mr. Das.
My lord, now one
What is it? What is this rate? One is 1,99,001. Page 85. This is Kothia Toli. Hello. This one. Next day also, Mr. Das, if I am correct, I don't know, page 85.
Page 85 would be
Part of the affidavit of respondent number
4, I think, my lord.
1, 2, and 3.
That's our affidavit, my lord.
Kindly come to annexer Roman 3. See the figures.
2 lakh 4.
Even on the next day, page 85, first row is your writing.
My
1368.66. 2 lakh 1 rupees. Next day, it fetched 2 lakh 4 rupees. Come to the previous page. Same thing, ACR lab wing, 1,91,000, 1,99,001 rupees. Those are very near to the dates. Even this 1,91,148 is on 24th February 2022, which is 3 days after your auction. By no means find closure. We also find out because of the pre-EMD amount, we also try to find out, but yes, anything?
My lord, just my lord, drawing your attention to page 118, my lord, and excerpt 4 to our additional affidavit.
114.
118, my lord.
8. Yes.
This is my actually for going to this my lord, reaction, my lord. Reaction we have suffered an amount of rupees of more than 4 crores, my lord. Because there is a vast difference the price between the quoted by the petitioner and the subsequent bidder, my lord.
He has purchased or not?
They have already lifted, my lord, on making the full payment, my lord.
Yes.
The forfeiture, the second paragraph, my lord, cost incurred for conducting a price auction may not be calculated as only manpower is involved in the entire process. And forfeiture of EMD is totally as per the terms and conditions of the auction. And the purpose of the forfeiture is only to discourage the bidders from hijacking the fair and transparent process of the bidding. Moreover, forfeiture of EMD is recompensate the power bidder against their time and efforts put in the commencement of the bidding process, which is result for failed due to the willful act.
That is the process. You have stopped the bidding process at 11:27 itself by quoting a rate. So they were happy. Yes.
No, moreover, my lord, actually, before entering into the system, my lord, the red quoted by the data was confirmed, my lord. About my lord, they are probably this. No, that is that.
Rate is not that is okay. There is no confirmation of rate over the.
No, confirmation. Entering into the system, there.
The system was confirmed. There is no dispute. There is no, what I am submitting was here. First of all, regarding the loss part, which we are submitting regarding the loss part, then I will submit. Had it been
No, Mr. Das, there used to be a EMD amount. You have not suffered. EMD amount, earnest. It is earnest. In every tender process. In some cases, it is also pre-EMD, that is to participate in the tender process. That can be there. But normally it is the EMD. It is not even the EMD in your case. It is only pre-EMD, which is pre-bid EMD part of the
process.
In normal tender process, what happens? That EMD has to be deposited. Then only, first they will see whether EMD has been deposited or not. Then they will only open the technical bid, price bid thereafter. They will see that whether bank guarantee or draft or whatever has been deposited or not, EMD. So EMD is the condition that this bidder is sincere in his approach or not. He is earnest or not to participate in a bidding process. That is the purpose.
That's EMD.
That is the EMD. And this EMD is also part of that, whether this man is a sincere bidder or not, or he is earnest. He has to show earnestness in the bidding process by depositing earnest money deposit. And consequence, if he fails, the consequence will follow. Right. Here the consequence is that if you do not submit the entire EMD within 7 days,
After being the successful bidder.
after emerging as the successful bidder, this has to be forfeited. And no doubt you emerge as a successful bidder otherwise. That plea you have taken now is that I did it because of some mistake. We try to examine this whether it is a mistake, bona fide from every angle, because your proposition is that I intended to quote 20,000. That explanation has fallen flat because of all these rates quoted in case of similar lots, and even at higher rates, auction was completed. So that has fallen flat. Had it been a case that yes, I intended that, you could not also do. I intended for 1,70,000. You could not do because it is not similar. So only plausible explanation you can put forward is instead of 22 lakh, I actually intended for 20,000. That explanation is by no way is a reasonable one. It is, in fact, totally unreasonable and totally irrational. Anything.
When I am aware of the fact that if I am not able.
Consequence has to follow, Mr. Das.
I'm what I'm saying also here that once
You have other product. I have heard many times. That is a consequence.
What I like is that here, when this amount, whatever is the amount, when bona fide mistake, so my only submission, a bona fide mistake, whether the mistake can be understood from the contract reading of the PMD amount, the moment I came to know, and the factor that there will be the loss, there is no loss of third is here I am, and there can be a similar case, it has been decided in before Madras High Court. Similarly placed. That place, which I may be allowed.
I have seen it. I will beg to differ.
Hamid Enterprises. Which,
I'll beg to differ.
and in the same, this case was there again taken to the division bench. This is a single bench of Madras. High
That was a case of upset price. Is it not?
It's the same. There was no upset. It's the same. There was no price given. And this judgment was again taken to the division bench. And the division bench uphold the judgment of the single.
Now,
Here
if
we
I,
have to place- This is regarding the EMP amount. Division bench uphold the view of the single bench.
because I also examined that aspect on the earlier date. Let me now have it. Let me now have the agreement. Come to page 73. Of the case paper.
The document would be an
Clause 7.6.
reserve price must be fixed.
Selling agency agreement.
Reserve price must be fixed.
And entered by the principal.
With a secret password in the website, which will be accessible by the designated authorized designated authorized officer of the principal only and none else for the disposable materials. In case the reserve price is not entered by the principal prior to the commencement of the auction, the lots for which the reserve price has not been entered shall then automatically withdrawn by the secretary. Here, what is the
It is
reserve price?
automated. Everything is automated.
In case, if I read again,
Read again.
reserve price must be fixed and entered by the principal with its secret password.
Who is the principal?
Principal is Coal India.
Target.
Powergate, sorry, Powergate. Powergate is the principal. In it, with its secret password in the website, which will be accessible by the designated authorized officer of the principal only and none else for the disposable material.
Disposable means lot.
The law. In case the reserve price is not entered by the principal prior to the commencement of the auction, the lots for which the reserve prices have not been entered shall stand automatically withdrawn by the system, meaning thereby that there was a reserve price. That reserve price is not reflected anywhere in this affidavit.
Why it is
That-
required?
If the we can see as to what it was the reserve price. If it was around 40,000, 50,000, that may change the. That information may be.
That's because of the contemporaneous material and as price fetched by the next bidding process.
No, but there is a reserve price, the minimum price which the power is wants to buy. Lordship may take it at day after tomorrow with the.
No. We have heard it enough, Mr. Das. We are dictating the order. No, no way. No way.
That information may be bought.
We'll read your Madras judgment. We'll read your Madras judgment.
And the reserve price may be that information.
No, if the court does not feel like asking for such query, why should?
That is. The,
Madras, okay.
Madras. If Hamid Enterprise is data in institute. Order. Page 904.
What is the story here? Let us read paragraph 2. Which one? Division means.
Before that, single bench.
Yes.
Challenging the order of first on the basis 25 10 for the 12 forfeiting the PPTNB of 5 lakh paid by the petitioner and for a direction to return the sale amount with 12%. second respondent for the purpose of participating in the auction conducted by the second respondent. An advertisement was put in the website that sale of contempt electrical materials lie in the premises of first respondent under reference to the such petitioner participated in the auction conducted on 13/9/2011 by the second respondent, who is the agent of the first respondent. The petitioner paid an amount of ₹5 lakh by way of demand draft drawn on Indian Overseas Bank, Chennai, at 12/9/2011 for the first respondent as prepaid earnest money deposit prescribed as a condition for participating in the auction. According to the petitioner, while participating in the auction, the petitioner quoted the bid amount of 12 lakh 24,202 for the added instead for the entire material. However, while typing the figures, 2 zeros were added instead of 1 zero after the figure 2 to make it appear as 1 crore 22 lakhs 42,002 instead of 12 lakhs 24,200. The auction commenced at 11 o'clock on 13/9/2011 and ended around 12 noon at the same day. Petitioner, having found the typing mistake, immediately gave a written receipt to both the respondents at 2 p.m. On the same day, through a letter and stated about the inadvertent error kept in the typing of the amount and requesting the respondent to accept the conditional fee for 12 lakh 24,202 instead of 1 crore 22 lakh 42,002. As there was no response from the first respondent, petitioner requested the first respondent either to accept the bid for 12 lakh 24,202 or to return the pre-bid amount of 5 lakh. Since no reply was given with regard to the acceptance of the tender or with regard to the return of pre-bid amount, pre-bid EMD, petitioner sent a reminder to the return of the EMD stating that if bid having not confirmed, it is entitled to get back the EMD amount. Petitioner's contention is that the first respondent has not informed as to whether the petitioner's bid was accepted or not. Petitioner, having no other option, called the council's notice on 10/8/2012. Both the respondents have called upon them to refund the EMD amount. To acknowledge that after the receipt of the detailed notice, the detailed communication was issued by the first respondent the amount of forfeit. There also is challenge to containing the forfeiture of the EMD by the first respondent arbitrary and excessive having been sold to subsequently auction for 45.52 lakh. Respondent ought to have returned the petitioner's EMD as the genuine error committed by the petitioner was form from the first respondent has filed a counter affidavit containing the issued order being a reply issued by the council. Stating that the forfeiture of EMD, the same cannot be challenged. Petitioner's offer being high, the same was accepted by the second respondent, thereby the contract was concluded. Therefore, the petitioner is not entitled to resile from the contract. In terms of the auction condition, EMD can be forfeited if the highest bidder fails to pay the balance amount within 7 days. As per clause 2 of the agreement, the first respondent is principal, the second respondent is selling agent for a period of 3 years with effect from 12/10. And the petitioner can face his right only for as per the agreement. The auction was conducted on 13/9/2011 and the second respondent informed through the same information letter on the same day that the pre-bid amount will be forfeited as per the terms and conditions if the petitioner does not make the balance payment within 7 days. As per the auction terms and conditions, if any bid is more than 5 times of the next lower bid, a confirmation will be sought for by the operator itself. Petitioner's bid was more than 5 times and the petitioner also reconfirmed the same. It is not a genuine error as alleged by the petitioner. It is further stated that the second auction was conducted and the sum of 45 lakhs 62,000 was quoted by the highest bidder, which was confirmed. Thereby, a loss occasioned apart from the expenses and inconvenience due to the pre-auction, which was had to be compensated by the petitioner. The forfeiture of the EMD is only by the compensation for the bid, which arose around under clause 70 of the terms and conditions of the auction. The bid amount quoted by the petitioner was not for a sum of 12 lakhs 24,202, but for a sum of 1 crore 40,002 as the immediate next is 22 lakhs 55,848. Second respondent filed a counter affidavit supporting the stand of first respondent justified the court. An additional affidavit was filed by the respondent stating that the expenses for conducting the auction. It stated that the total expenses incurred for releasing the advertisement newspaper came to 79,904 and the voucher for publication of also includes. Third, Mr. Sachin Leonard Council for responding and for the second. Point number 7. I have considered the rival commissions made by the Learned Council for the respective parties to produce the file, material, papers, student titles which are relevant. The issue arises for consideration into whether the respondents are justified for paying the AMP amount of 5 lakhs paid by the petitioner for participating in the auction held on 13/9/2011 on the facts and circumstances of this. It is not in dispute that an advertisement was issued by the second respondent on the website regarding sale of contempt elections lying in the premises of IIT Chennai for conducting e-auction on 13/9/2011 by the second respondent. The second respondent is the authorized agent of the first respondent. It is evident from clause 12 of the selling agency agreement dated 12/10/2010 entered between the first and the second respondent. Thus, the second respondent has no independent power to confirm the bid of petitioner and action is subject to the approval of the first principal will be the owner of the material. In the order issued by the second respondent giving direction to deposit an amount of 1 crore 24 lakh 1 crore 24 lakh 22,007 days in favor of the registrar IIT Chennai. It specifically stated that the auction has been provisionally accepted subject to the approval of by the seller in the first respondent. He did no scrape of paper finally approved the bid by the first respondent. Thus, finality of the acceptance of the business which has not been reached. In the dictionary reported in 1994, India, it pointed out that acceptance of the offer must be unconditional and the conditional submission of tender or acceptance of tender cannot be approved, which is one of the parameters considered while challenging the validity of tender or matters arising out of tender procedure. It is not in dispute that the petitioner having her informed on 13/9/2011 itself, the first respondent that the petitioner had wrongly added 10 in the amount quoted, making a difference of 1 crore rupees. Whether the said condition is right and made acceptance can be considered in the following angle. According to the petitioner, no upset price was fixed for the value of the condemned electrical materials under auction and some of which 5 lakhs was the pre-bid amount, considering the residual percentage of the market value of the step value. From the file produced by the first respondent, it is evident that the valuation was technically arrived at by taking the highest and lowest value fixed at the sum of 20 lakhs 75,000 was fixed at the reserve price. The state fact with fixation of upset price the reserve price was admittedly not disclosed in the key auction notice issued by the second respondent to the prospective buyer. The counter affidavit filed in this fixation of upset price before commencement of the auction process and making the same known to the intending participant is not taken. Thus, there is a clear illegality committed by the respondent in conducting the auction. It is a well-settled principle of law that obligating to act fairly by the administrative authorities was evolved to ensure the rule of law and to prevent failure of justice. Whether disclosing the upset price of the reserve price while conducting public auction to sell public property was mandatory or not was considered by the Honorable Supreme Court severally. In the decision reported in 2004, Anil Kumar Srivastava by the state of UP, the importance of fixing reserve price was emphasized. That the public is informed by the fact that the sale is subject to a reserve, that is, the auctioneer has agreed to sell for the amount which the bidder is prepared to give only in case the amount is equal or higher than the reserve price, which puts a limit to the authority of the auctioneer, and the auctioneer cannot accept a price below the upset or the reserve price. In 2009, 13 SEC Rani Aloka Durodure versus Govind Duroya, the Honorable Supreme Court held that the fixation of the price of the property in question before auction is mandatory. Though the says that
Wherefrom that judgment says that that information to be given to the bidders about the reserve price. Wherefrom this judgment has said that information about the reserve price is to be given beforehand to the bidders.
2004 ESCC 671.
But the division bench says, if you see that division bench examined the issue from the angle that whether the figure quoted was astronomical And certainly much more than the value of the scripts comparing with the amounts quoted by other bidders. The appellant ought to have examined the fact as to whether it was a mistake or genuine. Basically, it is to be seen whether it was a genuine mistake or it is a.
They, on that day itself, they came to the conclusion, they did not say that they call for it.
There is no issue regarding approval. That approval was not there of the seller. It was only agent. No paper was produced as regards approval granted by the seller.
The reserve price, Lordship has told me that in fact, regarding that 7.6, that there was some price which was been ascertained by the power grid. That price is still not known. And here, when the reserve price is needed, now here, if the.
Did you participate in any other bid of scrap material?
Other materials we have participated. We have been I have been a scrap material buyer since last 7 years.
Yes, like ACSR.
Like ACS, in the same kind of lot, I do not have that.
Because you have scrap
Other scrap materials.
deals in scrap materials.
In fact, there is no occasion of any other. I can bring the on record what are the other scrap materials which I have purchased.
Sale is basically as is where is basis. And there was inspection period. Inspection period of about 19 days. As per page 30.
72 it was given.
From 1/2/2022 to 19/2/2022. And this is as is where is basis. Here the agreement is about fixation of the reserve price by the seller with the agent. And if this is not there, then auction would not be held. That is the agreement between the principal and the agent. If reserve price is not entered, then it will be, the system will not proceed. But question of informing the bidder about the reserve price, that is not there.
Absentee judgment holds that here the question had the reserve price been known to us and it is that we know.
These should have been after participating in it. That law is, you cannot cry foul after that.
Here also they have participated, here the judgment is also they.
You are a prudent businessman, considered to be prudent business
In
because
fact,
you are,
in this judgment, the bid process was completed after.
that is
completion.
abnormally high.
After
that is-
completion of the bid process, he informed. Here too, yeah, before completion of the bid process, I informed.
The division bench judgment, when the figure quoted was astronomically high. It is not a case of astronomically high figure. It is very near to the actual figure. Fact.
That is, my,
Every case depends on its own fact.
lordship, that is, my.
Hard. The petitioner has instituted the instant writ petition as prepared under Article 226 of the Constitution of India. Seeking setting aside and quashing of a sale intimation letter dated 21/02/2022 issued by the respondent number 4 to the petitioner, whereby the petitioner had been informed that the petitioner's bid against the auction lot of ACSR lab wing conductor having containing 1368.66 metric tons at his quoted bid value of rupees 2 lakh 1 rupee per metric ton had been accepted. Full stop. The petitioner was the petitioner has also sought for a direction in the nature of mandamus to the respondent authorities to refund a sum of rupees 34,49,900, which the petitioner had deposited as pre-earnest money deposit within bracket EMD to participate in the auction process initiated by a auction notice dated 17/2/2022. Full stop. The petitioner has also sought for a relief in the form of a direction to restrain the responding authorities from initiating any further penal action in terms of clause 2 of the auction bid document. Of the auction notice dated 17/2/2020. Full stop. In order to understand the nature of controversy involved in the case, the necessary and relevant facts can be delineated, in brief, as follows. Okay. By the auction notice dated 17/2/2022 by auction notice, the respondent number 4, Messrs. MSTC Limited had initiated an auction process for the purpose of auctioning a lot named and styled as lot number 1 of ACSR Lapwing Conductor, which were lying at Bihapukuri Roman 1 store, page 31%, village Bihapukuri, Vishwanath Sariali, district Vishwanath, Assam. Full stop. As per the auction notice, lot number 1 contained 1368.66 metric ton of ACSR Lapwing conductor. An inspection period from 1 to 2022 to 19 to 2022 was provided for the prospective bidders the proposed auction materials were offered for sale on as is where is basis X dash works owners. Full stop. The owners of the proposed auction materials, that is SCSR Lapwing with Lapwing conductors, was Messrs. Power Grid Corporation of India Limited. Full stop. Stop here. The auction notice further mentioned that the quantity within bracket number, comma kg, comma mt, comma etc. bracket close indicated against the materials where unit of measurement within bracket UM was lot were purely indicative and without any guarantee, and the seller could not entertain any complaint from the buyer for any deficiency in quantity or for recovery of the whole or part of the money or any loss of profit, stroke interest, stroke damages and otherwise. Full stop. It was further indicated that the seller was not liable to weigh such items while delivering. Full stop. Para. The auction notice further indicated that a participant bidder had to have a pre-bid EMD amount of rupees 34,49,000. Full stop. A bidder, in order to participate in bidding for not like and such pre-bid EMD amount was required to be deposited at least 1 day prior to the date of e-auction. Meaning thereby, comma, no one was eligible to participate in the said auction process, comma, initiated by the auction notice dated 17 to 2022, comma, if he did not have a minimum amount, a pre-bid EMD amount of rupees 34,49,000 in the pre-bid wallet. The petitioner, who has claimed to be a reputed contractor dealing in lifting of scrap materials and selling them thereafter, comma, decided to participate in the auction process initiated by the auction notice dated 17 to 2022. In order to be eligible to participate in the auction process for lot number 1, which had indicated about the pre-bid EMD amount of rupees 34,49,000 transferred an amount of rupees 36,61,000 to the EMD wallet on 19 to 2022. The auction process, as part of auction notice dated 17 to 2022, comma, the auction process was to commence at 11-00 hours on 21 to 2022 and was to close at 16-30 hours on 20-01 2002 21-02 2022. Para. It is the case of the petitioner that when the auction process commenced on 21 to 2022, he took part in the same, and at one point of time, comma, he quoted a figure he quoted the figure at 2,01,000 rupees per metric ton. Full stop. At a later point of time, the petitioner has claimed that at a later point of time, during the auction process, the petitioner realized that he had quoted a figure other than a figure he intended to offer for lot number 1 containing AC, SR, lapwing conductor. Full stop. Realizing in order to correct the same comma, the petitioner stated to have informed the nodal officer of the response number 4 at exactly 16:30 hours by way of an email stating that an error had occurred in that the petitioner had mistakenly offered a price of rupees 2,01,000 rupees per metric ton, instead of rupees 20,001 rupees per metric ton. Full stop. The petitioner has claimed that he had sent the email for the purpose of modification of his offer from rupees 2,01,000 rupees per metric ton to rupees 20,001 rupees per metric. Full stop. The petitioner has alleged that instead of responding to his said email and subsequent correspondence made with Messrs. PGCIL authorities immediately thereafter, the respondent authorities, more particularly, the respondent number 4, by the impugned sale intimation letter dated 21/2/2022, sent at 22:35 hours, had confirmed the auction process arbitrarily and irresponsibly. Full stop. With such contentions, the full stop. As by agreed by such actions on the part of the respondent authorities, the petitioner has stated, has averred that agreed by such actions on the part of the respondent authorities, the petitioner is compelled to approach prescourt by the instant writ petition seeking the reliefs, mentioned. I have heard Mr. R.J. Das, learned counsel for the petitioner. Anybody for respondent number 4? Mr. N.C. Das, learned senior counsel, assisted by Mr. A. Das, learned counsel for the respondent number 1, 2, and 3, and M.S. P. Bulwa, learned counsel for the respondent number 4. Mr. Das, learned counsel for the petition, has submitted that the figure quoted, figure at rupees 2 lakh, 1 rupees per metric ton was quoted by the petitioner mistakenly. Full stop. It is his submission that the petitioner intended to offer a rate of rupees 20,000, 1 rupees per metric ton. But the rate got quoted at rupees 2 lakh, 1 rupees per metric ton erroneous. By referring to the documents, by referring to an email, shown to be sent at 4:30 p.m. on 21/2/2022 to the respondent number 4, Mr. Das has submitted that the petitioner, realizing the mistake, claim to be bona fide, had immediately informed the petitioner, respondent number 4, that his bid should be considered at rupees 20,000, 1 rupees per metric ton. Mr. Das has further submitted that the matter, the matter was also brought to the notice of the authorities in Messrs PGCIL by another email of event date, sent at 7:16 p.m. The petitioner had also requested the respondent authorities that to look into the matter and to take necessary steps to invalidate and cancel his offer stroke bid for a said auction process because of the mistake at mistake in quoting the figure. It is his further contention that where is your contention regarding reserve price, any averment made?
No, my lord. Yeah.
Then this is outside the pleading that, which I cannot. Uh, He has, Ms. Das has further submitted that if the impugned sale intimation letter is given effect to, comma, the petitioner is would be visited with severe adverse consequences in the form of forfeiture of the pre-EMD amount of rupees 34 lakh 49,000. As he has not deposited the EMD amount within a period of 7 days from 21 to 2022, comma, as stipulated in the impugned sale intimation letter dated 21 to 2000. Mr. The respondent sites have submitted in similar lines. Full stop. Mr. Das, senior counsel, appearing for the respondent number 1 to 3, has submitted that the auction process initiated by the auction notice dated 17 to 2022 was conducted by the respondent number 4 as its selling agent as capital A capital. Pursuant to an agreement executed on 30/11/2019 between Messrs PGCIL on one part and Messrs MSCC Limited on the other part. Full stop. By the said agreement, comma, the respondent number 4, comma, Messrs MSCC Limited has been engaged as the selling agent for sale of all movable stroke immovable items and all surplus, comma, condemned stroke scrap stroke obsolete materials and etc. and as well as equipment, comma, plant, machineries properties and miscellaneous articles, etc. through through Messrs to the auction website of the respondent number 4. Full stop. The terms and conditions. Mr. Das has submitted that the terms and conditions as regards engagement of the respondent number 4 as a selling agent have been clearly mentioned in the said agreement, which is valid for a period of 5 years. Full stop. It is his further contention that the plea raised by the petitioner that he had misquoted the price of the lot at 20,001 rupees per metric ton is not acceptable in view of the fact that in view of the then prevailing rates, market rates of such kind of ACSR Lapwick conductors within brackets CAT. Full stop. By referring to the various figures, stroke rates, which were fetched in a number of auction process conducted and concluded either prior to 21 to 2022 or subsequent to 21 to 2022. He has submitted that the rate at rupees 2,01,000 per metric ton was not an unreasonable irrational and astronomically high figure. He has further contended that sufficient safeguard was provided in the auction website of the learned counsel for the respondent have submitted that sufficient safeguard were provided in the auction website of respondent number 4 for the bidders in that even after quoting a figure, the the bidders used to get a message in the form of a pop-up displaying the bid amount in figures as well as in words. And the bidder had to reconfirm in the system thereafter that they would want to proceed with the said bid amount. Full stop. It was only after the bidder gives a confirmation to the figure he had quoted earlier, comma, the system records the figure. Full stop. Thus, the question of bona fide mistake, comma, or intentional mistake or unintentional mistake does not, cannot be a factor for the, cannot be a factor as after confirmation the bidder was not permitted to withdraw his offer. আগতে লিখি দিব Mr. Das. Mr. Das in support of his to buttress his submission. No, yes, Mr. Das has further submitted that the in an auction process, it is imperative in an auction process to have a reserve price, and such reserve price was to be fixed prior to commencing of the auction process and also had to be intimated to the proposed bidders in support of his such contention, comma, Mr. Das has relied upon a judgment of the High Court of Judicature at Madras in judgments in WP number 29701 of 2012 within bracket Messrs. Hamid Enterprises versus the registrar and another, comma, decided on 18/9/2014 and WA number 1378 of 2014 within bracket the registrar, comma, Indian Institute of Technology versus Messrs. Hamid Enterprises, bracket close, comma, decided on 21/8/2015 and arising out of WP number 29701/2012. I have duly considered the submissions of the Learned Counsel for the parties, and I have also gone through the materials brought on record by the learned counsel by the parties to their pleadings. I have also gone through the decisions relied by the petitioner side, the Sekut's decisions relied, the aforementioned two decisions, relied on by the petitioner side. Post. Well, the by the tender auction notice dated 17/2/2020. So sorry, the auction notice dated 17/2/2022 was published by Messrs. At respond number 4, Messrs. MSTC Limited. Full stop. From the agreement dated 30/11/2019, annexed to the case papers, it is noticed that the same is a selling agency agreement having a validity period of 5 years from the date of signing of the agreement, with a provision for extension for further period. No, agreement registered on executed dealer. Full stop. As per the said selling agency agreement, Messrs. MSTC Limited has been engaged as the selling agent for sale of this 71 for sale of all movable stock, immovable items, and all surplus, condemned stock, scrap stock, obsolete materials, and secondary arising within bracket ferrous and non-ferrous, as well as equipment, plant, machineries, properties, and miscellaneous articles, etc., through MSTC's auction website, www.mstcecommerce.com. Full stop. The agreement has referred as per the agreement, the Messrs. Power Grid Corporation Limited is the principal, and Messrs. MSTC Limited is the selling agent. Full stop. It has further laid down that Messrs. MSTC has to arrange disposal of the materials primarily through e-auction via their website www.so-and-so. According to clause 7.6, a reserve price is to be fixed and entered by the principal within bracket with its secret password bracket close in the website, which is accessible by the designated stroke authorized officer of the principal only and none else, for the disposable materials. Full stop. In case the reserve price is not entered by the principal prior to commencement of the auction, the lots for which the reserve price have not been entered shall stand automatically withdrawn by the system. Full stop. Fair. The auction notice had provided for an inspection period that is, from 1 to 2022 to 19 to 2022, for the intending bidders to inspect the materials of lot number 1 containing about 1368.66 metric tons of ACSR lapwing conductors, which were to be auctioned on as is varies basis. Full stop. It was clearly mentioned in the auction notice that the seller would not entertain any complaint from the buyer for any deficiency in quantity. And on no complaint basis, it was further indicated that the materials were to be sold on the assumption that the bidders had inspected the same and were in the know-how about what they were buying, irrespective of whether they had first inspected the materials or not. Full stop. From the bid summary or bid, where is that bid? That statement. 114. From the bid history of the auction process, held and concluded on 21. The other one? Other one is the same, the running page. Connection 3, why it is 25? Repetitive operation of
Twenty, 25.
We didn't see all this first of it's not.
Today I have produced before. Lordship.
From the bid history of the auction process, held and concluded on 21 to 2022, placed before the court by Mr. Das, Narendra Sitting Council appearing for the respondent PGCIL authorities, Messrs. PGCIL. It is and marked as document Act. It is noticed that the auction process started with receipt of the first bid at first bid of rupees 1 at 11:35 11-35-01 AM. Full stop. Subsequent to the first bid, 7 more bids were received. Full stop. The petitioner entered into the bidding process as the ninth bidder at 13-27-52 hours by quoting a figure of rupees 2 lakh 1 rupees per metric ton. Full stop. The bid previous to the petitioner was at rupees 1,000 per metric ton at 13-27-49 hours. MS Borua, Learned Counsel, appearing for the respondent of court, has also placed a document dated 27/3/2023 issued by the branch manager MSCC Limited Guwahati, which also indicated that the rate, the bid previous to the petitioner was at 13, was received at 13-27-49 hours, and the bid, the value, sorry, and the figure quoted by the said bidder was rupees 1 lakh per metric, 1,000 per metric. Document X or Y. In order to examine as to whether the figure quoted by the petition at rupees 2 lakh 1 per metric ton for lot number 1 containing ACSR lapwing conductor as a as a unreasonable, irrational and astronomically high, one has the contemporaneous, sorry, the auction process. Auction processes held for similar identical materials, that is ACA, SR, lapwing conductors can be looked into. ACSR stands for aluminum conductors steel reinforced. From the materials, from the case papers,
Just a minute, I'm sorry, my lord, it's another three to my affidavit in opposition that can be looked into, my lord. About the price quoted, my lord, by the other bidders, my lord.
no, that is in the subsequent.
No, in the earlier, my lord.
Huh?
Earlier.
For other,
Yeah, part
Next,
yes. The amount that quoted by him cannot be said to be an exorbitant, my lord, because in comparison to the price quoted by the other bidders, my lord.
Annexure 3 of the affidavit in opposition.
Sorry, my lord, I should have pointed out.
I am coming to that. I am just coming to that. From the case papers, from the papers, no. From the case papers, the details of one, two, three other auction processes, held and concluded for identical materials, that is ACSR, lapwing conductors, can be noticed. Full stop. From the case material, more particularly, annexer Roman 3 of the counter affidavit of the respond number 1 to 3. One of such auction process was held on 3/12/2021, that is, prior to the auction process in the case in hand, for 273 MT of ACSR lapwing conductor. Full stop. The said auction process fetched a price of rupees 1,99,001 rupees per metric ton. Full stop. Another auction process was for identical materials, that is ACSR lapwing conductor, for 223.41 metric ton, was held and concluded on 22/2/2022. That is, just 1 day later than the auction process in the case in hand. And the said auction process fetched a price of rupees 4 per metric ton, comma, which is higher than the figure quoted by the petitioner herein by claiming that the said figure was unreasonable, irrational and astronomically high. Full stop. In another auction process held and concluded on 24/2/2022 for ACSR Lapwing conductors, comma, the price fixed was rupees 1,91,148 for 1452.56 metric tons. Para. During the pendency of the writ petition, comma, and after disinclination on the part of the petitioner to deposit the balance EMD amount within the period stipulated in the impugned sale intimation letter, comma, a fresh auction process. Now, another auction process for disposal, for auctioning lot number 1 same lot number 1 was undertaken on 14/9/2022 after issuance of a auction notice. Where is the quantity? Next page, in my external page, running page, please tell. And except 12 of my additional additional epidemic 96. The respondents have brought to the notice of the court that the lot number 1 of 1 containing the quantity of 1368.66 metric ton of ACSR Lapwing conductor was part of another auction process initiated subsequent to during the pendency of the writ petition and subsequent to this inclination on the part of the HECNI. The said auction process was held on 14/9/2022 and the highest bid was received at rupees 1,70,000 Two. Full stop. Subsequent to the conclusion order. So subsequent to conclusion of the said auction process. Comma. The highest bidder deposited the entire amount there is a letter 4.1 crore.
118.
118. And the amount of rupees 23.27. What would have been your amount?
7.67.
Okay. An amount, okay, this amount is different. Phase 115, that amount is different because of other quantities. Okay, an amount of rupees 27.37 crores for the materials for lot number 1, which was earlier part of the auction notice dated 17/2/2022. By looking at the figures fetched for identical materials, that is SC, SR, Lapwing conductor, in the 3 auction processes held on T12/2021, 22/2022 and 24/2022, and in the subsequent auction process held on 14/9/2022, after in respect of lot number 1, after the failed auction process initiated after the failure of the after non-conclusion of the auction process initiated by the auction notice dated 17/2/2022. One cannot it is not possible to take a view that the figure quoted by the petitioner allegedly, mistakenly, allegedly by mistake, at rupees 2 lakh 1 rupees per metric ton was unreasonable, irrational, or an astronomically was an unreasonable or an irrational or was unreasonable, irrational, and astronomically high one. Full stop. The rather, the figure at rupees 20,001 per metric ton, which the petitioner intended, which the petitioner has claimed that he intended to offer, for ACSR lapwing conductors is an unreasonable, irrational, and extremely low one, and by no stretch of imagination, it can be said that the it can be said to be it is said to be it can be said that the figure, the said figure quoted is relatable to the SCSR lapwing conductors. Full stop. By the sale, by the impugned sale intimation letter, dated. No, there is another aspect which does not go to support the plea raised by the petitioner. Full stop. That his quoting of the figure at rupees 2 lakh 1 was due to a bona fide mistake. Full stop. As per the stand from the no. The stand taken by Messrs. MSDC Limited is to the effect that the auction portal provides a completely automated, transparent and unbiased platform to the bidders to compete for buying auction items. Full stop. as per the auction system, as per the auction process, comma, which is stated to be automated. Comma. As soon as a participant bidder quotes a figure during the live auction process, comma, say the said bidder gets a message in the form of a pop-up displaying the bid amount in words as well as in figures. Full stop. After display of the pop-up, comma, the bidder has to reconfirm in the system that he wants to proceed with the bid amount. Full stop. It is only after confirmation of the figure, comma, quoted both in words as well as in figures, comma, by the bidder, the system records the same, registers the same, and once the bid gets registered in the system, it is treated that the bidder is ready to pay the quoted price. Full stop. It is the furthest stand of the respondents that once registered, comma, a bid cannot be withdrawn, stroke modified by sending any email or correspondence either to the Messrs. MSTC, comma, the selling agent, or to the two Messrs. PGCIL, comma, the principal, either within the live auction period or any period thereafter. Full stop. As the system as the portal, as the auction portal, from the above, comma, it is evident that the auction portal has provided sufficient safeguards to a bidder to ascertain as to whether to proceed with the, as to whether to confirm if figure quoted by him at an quoted by him, and the bidder had an opportunity either to confirm the pop-up message generated automatically by the auction portal. Full stop. It was not a single opportunity for the petitioner as a bidder to quote a figure and thereafter to quote a figure. Full stop. Rather, there were two opportunities for the petitioner as a bidder in the said auction process. firstly, to put a figure, and secondly, after the pop-up message, to confirm or not to confirm the figure he had quoted earlier. Full stop. So any mistake. Such as the one indicated by the petitioner, could have been discovered with exercise of ordinary care and diligence. Full stop. The petitioner has sought relief in the form of it is the condition, it is one of the condition in the auction notice dated 17/2/2022 that in case of failure, condition that a bidder who had been successful in the auction process, was to submit the earnest money deposit within a period of 7 days from the date of e-auction notice for accepted lots. It was further stipulated that in case of failure to pay EMD, the said EMD amount for a auction process in case of lots for which a pre-EMD, for which deposit of a pre-EMD amount was a condition precedent, within the stipulated period, then such pre-bid EMD amount would be forfeited. Full stop. The by the impugned sale intimation letter dated 21/2/2022. The petitioner was informed that the material value of lot number 1 for the auction notice dated 17/2/2022, for which he had emerged successfully, was rupees 27 crore 37 lakh 3,337, and he was required to deposit the said amount as per the terms and conditions of the auction notice. A plea has been raised. The petitioner has sought relief in the form of a refund of the pre-bid EMD amount of rupees 34,49,000 on the ground of equity and bona fide mistake. Full stop. It is a settled proposition that it is well settled that equity follows the law. And where a mistake might have been avoided by the exercise of ordinary care and diligence on the part of the bidder, and where the bidder can, by exercise of ordinary care and diligence, could have avoided the mistake, such a bidder cannot be permitted to take the advantage to take it, to take is not entitled for any relief on the ground of equity. Full stop. The petitioner has contended that by abandonment of the auction process initiated by the auction notice dated 17/2/2022, which had to be abandoned due to disinclination on the part of the petitioner to deposit the EMD amount, and by the conclusion of the subsequent auction process for the same lot, held and concluded on 14/9/2022. It is the petitioner, the respondent authorities had not suffered any loss. Full stop. The respondents have taken a stand that had the auction process initiated by the auction notice dated 17/2/2022 had been concluded on the basis of the figure quoted by the petitioner at rupees 2,01,000 rupees per metric ton, the same would have fetched a higher amount, but a higher differential amount of rupees 4.1 crore. Such a plea is not to be countenanced, as it is due to the due to action on the part of the petitioner, as have been delineated herein above, the auction process initiated by the auction notice dated 17 to 2022 could not be brought to a logical conclusion, to a conclusion. Full stop. By quoting the figure at rupees 2 lakh, 1 rupees per metric ton, at 13 dash কিমান hours আছিল? 13 dash 27 dash 52 hours, the petitioner had, on one hand, stopped the other bidders and thereafter, by his disinclination not to adhere to the terms and conditions of the auction notice, had compelled the respondents to initiate a fresh auction process for the same lot at a after a period of about 7 months. Full stop. In view of the discussion made above, and for the regions assigned discussion, and for the regions assigned above, this court is not persuaded to arrive at a view that the petitioner is entitled to any of the reliefs, sought for in the writ petition. Consequently, the writ petition is found to be bereft of any merit and is liable to be dismissed. So it is accordingly dismissed. The two decisions relied on by the petition side. Two decisions of the High Court of Judicature at Madras, relied on by the petition side, is respect of an e-auction process. Wherein the petitioner deposited after depositing a pre-bid earnest EMD, participated in the said auction process. Full stop. The petitioner had contended that he had quoted a bid amount of rupees 12,24,202 for the entire materials mistakenly he had quoted a bid amount of rupees 1,22,42,002 rupees, instead of rupees 12,12,202, mistakenly in the auction process, said auction process. Full stop. It was contended that the same had resulted into quoting an astronomically high figure as the said as the same materials were subsequently were sold through a subsequent e-auction for rupees 45.52 lakhs. Full stop. On perusal of the decisions, it was noticed that the selling agent had no independent power to confirm the bid of the petitioner, and its action was subject to the approval of the principal, that is the owners of the materials auctioned. Full stop. The court had found that there was no approval from the petitioner of the bid provisionally accepted by the selling agent. Full stop. In the intercourt appeals directed against the judgment and order of the single judge, the division bench had considered the aspect as to whether the figure quoted by the petitioner therein was astronomical and whether the said figure was much more the value of the scraps comparing with the amount quoted by other bidders, and as to whether the writ petitioner stroke appellant, writ appellant, the figure quoted by the writ petitioner stroke appellant was a mistake, was a genuine mistake. Full stop. It is settled that a decision is based on so and so, so and so. this, the, figures fetched in the case in hand, comma, the figures fetched in 4 other auction processes for identical materials, that is ACSR, Lepuing conductor, have already been found to be near to the figure quoted by the petitioner hearing, that is at rupees 2,01,000 per metric ton. Full stop. The fact situation obtaining in the case, in the said two decisions relied on by the petitioner side, are not found applicable to the case in hand, and as such, the said two decisions are found to be of no assistance to the case of the petition. No cost. Yes, please. Cost, no cost. Good. Okay. Very comfortable. For this one.
Published.
We'll not get the order today. There has to be some correction. Monday.
Item number 4.
Yes, 4.
The petitioner side has already left, my lord. They have, my lord, actually.
Is there any assisting counsel?
No, my lord. They have requested me to, my lord, fix a date on 19th of February, my lord. Only that to that extent, my lord. He has requested me actually. They had a flight to catch it.
Not possible, because if this is a case of what? If exchange of pleading is complete. No local council.
Well, one local council is there. Her name is already there.
Who is the local council then? Yes, Mr. Dasgupta.
I am with him, Lord.
Informs on 6th of February will be taking up. 19 are motion day. On a hearing date, 6th of February. Interim order is operating. Is it not?
Yes.
Written submission. You have been furnished with the written submission.
Yes.
Okay, inform the what to record now. He is not there.
Yes.
Matter was, though Mr. P. Mehta, learned counsel, the petitioner, was present, learned counsel for the petitioner, an outstation lawyer, was present when the case was called up in the morning, the same was deferred for a time being at the instance of the respondents. Full stop. And as the learned senior counsel for the respondents was not available at the point of time.
I was in court number 7.
Will not record that. Was not available at that point of time. Full stop. When the case is called up again, Mr. A. Dasgupta, learned senior counsel for the respondents, is present, but the outstation lawyer appearing for the petitioner is found absent on call. Full stop. As an interim order is operating in the repetition. What is this case? Blacklisting.
Yes, yes.
Lays the case on 6-2. The interim order passed earlier shall continue till the next.
Number 7 and 8. 6, 11.
Yes.
Great delay on the part of the respondents.
Huh?
Great delay on the part of the respondents.
Grave delay.
Yes, doctor.
What kind of delay?
Doctor, 1 year has been 1 year has elapsed since Sarah has passed an order directing them to enforce an order. However,
Enforce
no
an
step-
order.
Yes, doctor.
So is this is the forum for enforcing the order.
Lordship, no steps have been taken by DC and there is no enforcement regulation under the RERA Act. Enforcement mechanism.
Yes, what is this?
Lordship, the certificate came from the RERA authority to the under Bengal Public Demand Recovery Act. So certificate officer, my lord, he has started the proceeding, and then the later he came up with a plea that he should be allowed to pay by installment. So that was rejected, refused by the petitioner. So hearing,
This certificate officer has sent a notice to the petitioner or not?
yes, yes.
Lordship, we haven't received any notice
Oh.
as such. Although they have been asking us to make a settlement and take installment payments from them.
Installment payment, that was
No.
goes to him, therefore, after
The
that,
profit, no, your case is that he has not proceeded with the proceeding,
Yes,
right?
yes, sir.
How he will proceed, in what manner he will proceed, that is not the lookout of this court.
Yes.
Your case is that he has not proceeded. The certificate was forwarded to him and he had not proceeded for a period of 1 year.
Yes.
Now a submission is advanced now that the matter has been proceeded with. Now, if he has not, if you are not, the manner in which he has proceeded, if not to your liking, that is a different aspect altogether. But some submission is advanced that the certificate officer is proceeding with the certificate.
Lordship, as
We are not here to execute the certificate. We are here to see whether the officer or the authority who has been entrusted with a duty, whether he has performed with a duty or not. Only to that limited extent. Now, if what is the
notices were sent to them, but
now you are saying that
I have the.
you have been informed that please accept the installment, meaning thereby you had a knowledge about the proceeding.
Lordship, but we don't want, as per the
That
regulation.
we are not here, madam. That Bakizai officer, please proceed with this manner. Please proceed with this manner. Or you proceed with this manner, realize everything, seize everything, seal everything. We are not here, madam. We want to see whether that authority who has been entrusted with the duty to execute a certificate, to realize an amount as an area of land revenue, whether he has proceeded or not, whether he is guilty of inaction. We are not here to decide the manner in which he has proceeded.
But how they proceed should be as per law.
Then I am dismissing. This is not the way. Your case is what? Come to prayer. Take immediate steps to recover. He has started the proceeding. What more?
Lordship,
Don't relegate this court to an executing court.
Lordship, then the petitioner will be left remediless.
Why?
Lordship, because DERA doesn't have any authority.
No,
Against the
MS, madam. The certificate officer who is in seizing of the proceeding now?
Certificate officer.
Who?
Uh,
You are proceeding in what manner? Under,
Bengal Public Demand Authority.
are you
So,
sure?
Yes,
Lordship, then.
Are you sure?
my lord, that's what it says, my.
No.
BDPN.
The,
BPD.
it is up to you.
BPD.
We are not here to advise. As per the RERA Act, it is to be recovered as a area of land revenue.
So area of land revenue comes under the Bengal Public Demand Authority.
Area of land revenue also comes under Assam Land and Revenue Regulation.
Yes, yes, ma'am.
Lordship, where,
Right. It is, yes.
where Assam Land and Revenue Act is enforced, Bengal Act will not be there.
So it is for them. Now the question is, if it is a public demand, then it is BPDR Act. Now it is a
Individual.
fight between what? Builder and?
Allotment.
Is it a public demand?
They can raise that. Yeah,
It is up to them.
up to them. And they have other immediate.
So why don't you file? This is a builder and a flat buyer dispute. RERA has passed an order.
Yes.
Area of land revenue. Now you have proceeded with BPDR Act. So if it is a public demand, it is well advised. Otherwise, law is also settled unless it is public demand. And if it is a case of area of land revenue, the recovery proceeding has to be under Assam Land and Revenue Regulation.
That they can always raise their money.
But where is your statement?
No,
File for affidavit.
I can.
How you have proceeded with, then we can examine. Because question of maintainability of the repetition is kept open. So if we are on the issue of mandamus and certiorari, madam, nothing less, nothing more. We are not intruding into another authority's jurisdiction.
Lordship, I have a citation of Bombay High Court which was later on affirmed by the Apex Court, where similar matter was placed before the court.
What
Where
matter?
the Tehsildar and the collector was not executing the certificate passed by RERA. So similar matter was placed and maintainability was in question. When the respondents questioned the maintainability, Bombay High Court said that the petition will be maintainable and the Apex Court agreed with the.
It is not a question of maintainability, madam. Actually, there are two things. One is maintainability. The other one is entertainability. Right. Maintainability part is that because there is a legal duty on the part of the authorities to continue with the execution of the certificate. Right. And to that extent, the petitioner has a legal right that his right should be enforced through that authorities. In case of inaction, yes, mandamus will lie. Right. But when the proceedings have been initiated by the authority, by initiation of issuance of notice, right, then we are not intruding into the, by running a parallel proceeding, whether he has proceeded rightly or wrongly. If something he has proceeded wrongly, then another question of, another cause of action will arise.
That is not their case, my lord.
Not their case. That is what I am. So that judgment, you can hand over the judgment, but question is about after initiation of the proceeding, he has done something wrongly. That would be a cause of action for another repetition, might be, but not in this.
They could have challenged that, the proceeding is wrong.
It's my humble submission that there are two writ
We are not enlarging the scope.
Lordship, there are two writ petitions.
Let them file the short affidavit, how he have proceeded. MS P. Gupta, learned counsel for the petitioner. Same order hobo duitate, huh? And Mr. B.J. Talukdar, learned senior counsel, assisted by Mr. P. Medhi, P.K. Medhi, learned counsel for all the respondents.
No, not all.
2, 3, 4, 1, 2, 3, 4. Okay. Mr. J. Hendrick, learned standing counsel, revenue and disaster management department for the respondent number 1, and Mr. B.J. Talukdar, huh? Senior counsel, assisted by Mr. P.K. Medhi, learned counsel for the respondent number 2, 3, and 4. So Mr. Talukdar has submitted that he has received instruction as regards initiation of proceeding by the state respondent authorities appearing for the respondent number 2 to 4 has submitted that proceedings have been initiated by the state respondent authorities on the basis of the certificate issued by the Real Estate Regulatory Authority Assam to recover the amount as arrears of land revenue under section 40 of the Real Estate within bracket Regulation and Development bracket close Act 2016. So stuff he has sought for
3 weeks.
why 3 weeks?
2 weeks.
2 weeks time to bring the status of the state proceedings by way of counter affidavit. He has thus sought for 2 weeks time. He has thus sought for listing of the case after 2 weeks. The prayer made by Mr. Talukdar is allowed to release the case after 2 weeks. Or did you give the detail? You release the case on 13/2. Same. Next order is same. Same.
Same only, my lord, their notice could not be served upon the respondent. Second case, he was not found in his address, the
Who is that?
builder.
Same builder. Different builder. We are not concerned with it. We are concerned with the proceeding. They are seeking mandamus on
Now
it.
we are,
How we have proceeded, that is what.
now we are serving notice to police.
We cannot run a parallel proceeding as a supervisory, having a supervisory jurisdiction. You proceed in that manner, you proceed in that manner. Yes, next. Possible. Anything you want date, we can give date now.
Lordship. May it please your lordship. Lordship, in this matter may be passed over for the day as
It
lordship.
will be passed
Lordship.
over for the day only.
Lordship, next day. Next day.
Next date. When?
Lordship, next week, 25th.
Not this month.
Then lordship, 2nd February.
What is the case? What is the story? There are two repetitions. You are appearing in which one?
I think 9.
9. Okay. And you are in
I am,
item 10.
In item number 10, I am the petitioner, and in item number 9, I am the respondent number 9.
What is your grievance?
Lordship, the
Yes, Mr. Sharma.
Lordship.
There are since there are two contesting sides. You
Lordship,
please
in
explain what is
item
the
number, in item number 9, Lordship, one notice was issued because he was cutting illegally the land. Because of that, Lordship, the neighbor, Lordship, that is the petitioner in item number 10, there is some danger. Accordingly, notice was issued that don't cut illegally. Challenging that, Lordship, he has come. And regarding that, the second one, Lordship, this
Bodon Chandra
Chandra
Bora.
Bora, Lordship, he has come regarding that illegal cutting of that land. Both the cases similar, Lordship, in
Why
item
illegal cutting of what?
Lordship of the hill.
of the
Not cutting
hillside,
activity.
Lordship.
Hill.
Trench,
On
Lordship,
which
because
the,
of that,
They are landowners.
Lordship.
Who is above? Who is below?
Lordship,
This
we are adjacent.
Huh?
We are adjacent to adjacent.
No, it's just end, but in a hill.
No, that is their allegation, they are contested.
No, no.
The hill, and
No, hill cutting is involved.
Yes,
In between the
two neighbors.
two neighbors.
And
So
Bodon
definitely
Chandra Das,
that means it is hill.
hill. This Bodon Chandra Bora, Lordship, he is in the downhill.
no,
From the report, it reflects like this.
Who is above? Who is below?
No, my lord, no one is.
Yes.
As a
Adjacent.
No, if it is a hill, hill is not plain.
Lordship.
Tell me, it is slope. Definitely it will be slope.
Yes. In slope, and my lord, they have constructed the building almost 20 years back. Thereafter, my lord, I have passed very recently, my lord, and my lord, I have not.
Who is above? Who is below?
My lord, we are in a slope. No one is above, my lord, on the my lord, same level.
Then if the same platform, Mister, this is found illogical.
Lordship, if your Lordship go by this.
Illogical.
Yes, Lordship, this 259, this bottom side.
Let us see, let us see. Easily understandable.
Lordship. And your Lordship may kindly that we have not filed any affidavit in this, but in item 10, Lordship, we have filed our affidavit.
No, I need the actual gradient.
That is not there, but
Nobody, otherwise we cannot visualize.
Lordship.
Sitting here.
But may I read that relevant portion, Lord?
We'll otherwise relegate them.
That is the
If you don't tell the story,
Lordship,
if it is a hilly slope, somebody must be above, somebody must be below. If it is a plain thing, there is no question of any. If it is a plain plot, please, Mr. Counsel, please give a patient here. If it is a plain slope, right, two plots, there is no question of any danger.
If your Lordship comes,
If it is like this,
then there will be danger.
danger.
Yeah.
Now who is above, who is below?
Lordship may kindly come to
Don't
page
you-
130.
Then I'll find out myself.
Page
You are not discllosing.
Page
Who is
130.
above, who
Lordship,
is
their
below?
colored photographs is there.
Huh?
Page 130.
And for the response number 4, my lord.
Who are you?
My lord, I am Director of Soil Conservation.
Which writ petition 130?
Item number 10, my lord.
10.
Colored photographs are there.
Colored photograph.
130, running page.
Running page
130.
133.
130.
Oh, 130.
Item
Running
number
page, Lord.
10.
This white building is of whose?
Bodon Chandra Bora.
Bodon Chandra Bora means item 10.
Petitioner in item 10.
And where is Mr. 9?
That adjacent land.
This land.
Yes.
And Mr. 10, his boundary runs where? It is the boundary.
Without constructing any boundary wall, they have constructed.
No, Lordship, our contention in the item number 10 is that we are seeking for the private respondent to build a guard wall.
Yes.
Because Lordship, due to their art cutting activity, which was already has been complained
Your building does not have any boundary wall.
Boundary wall. My lord,
Does not have any boundary wall.
does not have that. They are by my lord. The both petitioner and the respondent can enter into a contract also. an agreement whereby, my lord, I had a fifty.
It clearly emerges that your building does not have any boundary wall.
Lordship, then on the next day, my senior counsel will appear
No, I'm just asking.
because he will be
Reserve
able to
that
apprise this.
argument for a later day. I'm asking this does not have any boundary wall. Hmm? He has the permission.
Yes, Lordship. The
Permission,
this
but he has
permission.
a-
Permission, but every permission has setback boundary wall that from at least 5 feet, 3 feet, one should have the building.
But
They are
Lordship,
not
the
following this criteria.
but the
Malad, they are obtaining the permission only for Malad 2 story, but they are Malad.
no, Lordship, there is
No, one thing is there that your building is clearly a danger to the public road ahead of it, irrespective of whether respondent number 9 is concerned. Yes, Mr. Sharma, this building is clearly in danger to the public road.
Lordship. But if your lordships comes to page, the.
We'll not
running-
go to the page at 4:30.
No, no, we have assured the petitioner in item number 9 that we will provide all the technical assistance for guarding the.
No, why this dispute?
Malad, with all respect,
Why this dispute?
that's Malad, it is there, Malad, we have.
Okay, dispute is to be resolved on another date.
Malad, with all respect, Malad, just for a moment, Malad. Malad, I have not.
On the prayer of Mr.
M.R. Sharma.
M.R. Sharma, Learned Counsel for the petition, and Mr. B.K. Das, Learned Counsel. M.R. Sharma, Learned Counsel for the petition in WPC 118/2022, and Mr. B.K. Das, Learned Counsel for the petitioner in WPC 6133/2023. Release these cases. On 16 to Mr. H.R. Somal, additional senior government advocate for the state respondents and MS R.S. Dev, Reliance Standing Council,
Soil conservation.
Soil Conservation are present. Yes, any date to be fixed?
Much obliged, Your Lordship.
My lord.
22 matter. What is the case? Okay, we'll find out. We'll fix a date.
Item number 11, Lordship, Lordship probably remembers that advocacy act was involved.
Okay.
So please sorted.
Okay, sorted next week দি দিব 11 এইটো চাই ল'ব 18 টো চাই ল'ব এই চাই পেলাই ডেট এটা দিব Yes, Mr. Kejriwal. এইটো চাই ল'ম মই চাই ল'ম বাৰু চাই পেলাই ডেট এটা দিম And who about what about 16?
Number 12 maybe in middle of.
Okay. চাই ল'ব huh? And what about 16? No, no one. Okay, I guess I will did him from Puroni, no?